that it is pretty easy. See if we go to finance and we're still on the buyer side, there should be a closing fee there because that's the loan closing fee, not the title closing fee, right? If we're going to the seller side, again, you put in that stuff, you get to say is the seller paying or not. The other piece is down here in additional, if you want to put in anything like if there are any kinds of special assessments or agency fees, again, that's the seller's agent fee, that doesn't apply to you guys. But then credits and charges, so if your seller is going to give some kind of concessions to the buyer, everybody familiar with that piece? And you say, oh, the seller's going to pay X amount of dollars towards the buyer's closing costs, you can put that on too, and then your seller can see what they actually net out with. And it should be pretty darn close. So I think it's a very cool tool. The nice part is you don't have to call us at midnight for a quote. You can actually get the quote when you need it, because we're not usually at the office at midnight. But your clients somehow think that you are. So weekends and that kind of stuff, there you go. You got something up there, and you can see at the top the buttons are new, email, print, or you can order title off of the search you did, and you can save it. And those, I think it's pretty useful. Melissa uses it a lot.
I use it all the time.
Absolutely. So if you have any questions on it, and honestly, you can always text me and say, hey, Kevin, there's a mistake here.
I did not say that.
No. She actually said, is this right? And I said, no, it actually isn't. So thank you for that. It's actually was this past weekend.
I know, because I do rely on this a lot, and it's helpful to give an estimate, because they want to know that bottom number, and I don't always get that information accurately, so I like it.
So yeah, I appreciate your text and
thank you
asking the question, and it's fixed already, by the way.
I see that. I'm like, yay.
So.
You know what would be really nice?
What's that?
When I was doing a listing presentation or whatever, I get a listing appointment, take one of the net sheet out with me, and then when you get an actual contract, they always seem to, customer always seems to remember that the number was higher.
Yeah.
When you did at the listing presentation.
That's why that save button is pretty important.
Yeah, but if you had a comparison, that would be cool.
Well, and the other, that's actually, somebody has suggested that we try to do a comparison sheet, but the programmers have not added that to their thing yet. But when you're talking about a buyer and a seller, first of all, I got to tell you, I'm a title guy, but I'm a sales guy for a long time. So if you have two different sales prices and they're $5,000 difference, does that $5,000 difference affect your expenses as well? Do you think that your seller actually notices that? Not until you lay it right next to them and you go, look, you're $5,000 difference, but in reality, what you're talking about is a $4,000 difference. And you have ways to look at those numbers next to each other and make it a little bit more palatable for your seller to take and accept an offer. When they're fighting over that last $800, it's kind of silly. I've seen deals fall apart on $1.2 million deals for a $70,000 difference or a $50,000 difference, where the buyer and seller wouldn't come together. And you're like, really, you guys? You have $1.5 million, $1.2 million in this deal, and you're worried about the last 20 grand. So, and when you're talking about those kind of numbers, the difference in the expenses piece is big. So anyway, Jim, do you want to start, say anything, or what?
Well, I know we build this as a contract class, but I think you're all aware of the fact that I invited Kevin to come to focus more on the title.
It's pretty evident. I mean, he's here.
Well,
I'm just kidding.
So, if you came here thinking we were going to walk through a contract and prepare a contract,
We will do that too.
We can do a lot of that too, as long as we're fine. But I think a lot of times agents don't really understand the whole closing process and what goes into the title work behind the property, and that can mess up the deal like we were talking about earlier, right?
Yes.
Especially down here in Florida where you have so many houses that are owned in trusts or estates or LLCs or whatever, partnerships. You really need to make sure that the people that are signing these
I would have done that, but I didn't.
But the critical thing is you want to make sure that the people you're dealing with, whether you're doing a listing on a piece of property before you're writing up an offer to buy something, that the people that are signing the agreements have the authority to do what they're trying to do. And amazingly, a lot of the trusts that we see that are brought in from out of state don't give anybody permission to sell property in Florida, right?
It's true.
Yeah,
Yeah.
that's a big one that was kind of an eye opener.
There's a lot of things that you should always look out for, and I'll tell you, this is the first note to write it. When you're listing a property, if you see the word trust, estate, if you hear Uncle Bob left it to me, or Uncle Bob gave it to me, or which we're looking at quick claim deeds, or I bought it from a friend, and we just didn't use a realtor, which means they probably didn't use a title company. These are all things that have instances where the title can be flawed. And the other one is a power of attorney. If you hear the words power of attorney, especially if they're talking about their trust and their power of attorney at the same time, not legal, those are things that I would say, call us now, send us the property, let us search it. We're not gonna charge you for it. The fact is that we're gonna hope to get the deal when we're done. But in reality, you want to know if there are any problems now. We'll have a search done with, actually, if we need to rush one for you, it's because you're listing it, then we'll rush it. We can get it in a day. So usually turnaround is 3 days for us. But I would say let us search it now while you're listing it, because if there's stuff for us to clean up, and it takes 3 or 4 months to clean it up because we have to search out cousins of dead parties or some other significant scenario like that, the best thing you can do is have us doing the work while you have the property listed. Because if you have a buyer and money on the table and they have to wait 3 or 4 months to close because there's a title issue, a lot of buyers will walk. And you want to avoid that. So don't feel bad about asking us now. Sometimes we get the business, sometimes we don't. That's for anybody that has a trust, a will, a trust, wills, powers of attorneys, quick claim deeds, all of those pieces. We'd love to search them before you get into a bind. Yes.
I actually had one that you guys helped me get the listing
Mhm.
because there was 4 people listed on the appraisers and they didn't know who the 4th person was. So it turned out it was like a cousin that they'd forgotten was on it too. But the fact that I called and I asked Tracy and she was like, yeah, no problem, and reached out and sent me a response. I think in 24 hours she had figured out, everybody and found the paperwork and everything for us. And I was able to say, yeah, this is that. And they were like, wow, that's amazing. Sign on the line.
That's
So
wonderful.
yeah.
So by doing that legwork that nobody else really
Right.
probably cared to do,
Right. Exactly.
you earned the business.
Another thing you'll see is people put properties in an LLC or a partnership or something like that.
Mm-hmm.
And more than once I've seen where they haven't been doing the annual reports. So their entities actually,
The entity
Inactive.
has expired or something like that,
right.
and you either have to reenact it or do it as a wrap-up of the company. Some of those things are steps that, take extra time. So those are pieces that we can find in advance that will help you.
I think you told me like if an entity is created and it's a single purpose entity like that, the only thing they own is that piece of property
Mhm.
and they're inactive,
You can do it
You
as
can
the
just-
final wrap-up through an affidavit of the corporate.
right? So you don't have to reactivate it.
Right, which will save them like $575. Not every title agent will do that.
$575 for the filing fee,
The filing fee.
but I had a customer that had an attorney that took care of everything for me. Cost them $3,000 to reactivate a company that didn't have to be reactivated.
Wow.
Yeah.
Yeah.
So.
And we experience that a lot around here, because a lot of people that, investors that are buying homes, they
Yeah.
buy it in, it's that property LLC.
Or they'll get an attorney like to set up the LLC and they assume that the attorney's gonna keep renewing it on an annual
Right.
basis, and then they find out they don't.
Yeah.
That's not part of the service.
So the other question is, why is a quick claim deed a red flag? Because they're usually done at home. And the string of quick claim deeds is usually something that somebody has forgotten a marital status or forgotten a piece of the legal description. I actually had a lot that was between 2 neighbors on the end of PGI Canal. They had split this lot back and forth over the years and transferred it back and forth based on which one of the neighbors needed the money right now or whatever, and then the guy died. And so the property ended up being distributed through his trust. In one of the quitclaim deeds, they had missed a corner. So in reality, what they owned was a little triangle of this lot instead of half of the lot. And we had to track down the niece of the trustee because the trustee was also deceased. So that's why I say quitclaim deeds is usually, neighbors, friends, family members transferring property back and forth or doing it without a realtor and without a title company. And honestly, I would say even if it was done by an attorney that's not a specialist in real estate, we've seen some messy things there too. So it is something that's really important. There's some certain elements of a deed that have to exist, and that's one of the things that we look for all the time is trying to make sure that the deeds are valid. We're looking for that chain of title to make sure that you have clear claim to that property even after you buy it. Just because you went through a contract and you exchanged money doesn't mean you own it, does it?
Especially if they're related parties, right?
Yes,
A lot of times
especially if you're
people
related parties.
transfer property to their kids or to their whatever, and they think because it's just, well, Uncle Bob bought it a year ago, he didn't do anything to the property, but if you don't buy title insurance,
It could be a mess that takes a lot of attorney money, a lot of attorney fees that you have to pay to clean up, or you might have family that's not going to be family after you all make this final decision. Because I had a friend of mine, he used to say, he said, money can make people pretty, but it sure can make them ugly too. And so, and that's kind of one of the things. So, where do we want to go? Where do we want to talk about this? Yes. All right, let's talk about. You guys have this piece, right? Okay.
everything.
All right. So that's what we're going to go into right now. Schedule A, and one with my notes. Somebody, that's okay.
Does anybody have more notes on
Does
that?
anybody one with? There you go. That's okay.
Are these yours with notes, Jim?
Actually, those copies all have notes on it. So, this is the search itself. I gotta find my glasses because I'm blind. First of all, I want to tell you a couple of things. This is our office in Punta Gorda. This is 9 years in a row. We actually messed this early, 12 years in a row. So I should update that sometime. But I don't want to talk about all the people. But the fact is that if you haven't dealt with them, I have an amazing group of people. In all of my offices, they're a great group of people. And the reality is most of them have 15 years experience or more. Beyond that, we have 2 underwriters. Some people will say, well, I really, want to make sure that this is covered, so I want an attorney, especially if they're like from up north or New York. I guess those are different. I'm from New York. The fact is they're used to dealing with attorneys, and that's not necessarily the case in Florida, so it's hard for them to get used to. But in reality, if we run into any bumps, we're not advising the contract, we're not advising the buyer or the seller, but as far as how to get it closed and how to do it right and how to get it legal. If there are any nuances that we need an attorney's advice on, we actually follow the attorneys from the carriers. They both have big teams of attorneys that'll say, look, this is how you get this done correctly, this is how you get it insured properly, and here's how you get it to closing, which not all attorneys think about that way. Some of them just think about how to be super technical as opposed to getting it to the point of getting to closing. So
It's because they know their hourly rate.
yeah.
Do you do your own searches?
Our searches are actually done by the carriers. And the reason I do that is because I don't have to go to an outside party for my errors and omissions claims. I have errors and omissions coverage for myself if we make a mistake. But when you get your search and your policy from the carriers, if there's an error in the search or an error in the policy, guess who's responsible?
They are.
Right. So remember I was talking about transferring risk, and I talked about the documents you get from us with the fee calculation. You transferring that risk to us. Me, when I get my search and my policy printed from the carrier, I am paying them to take on the risk. And the nice part is about that is that we don't have to worry about the carrier and the searcher pointing at each other and going, no, it's their fault, no, it's their fault. The fact is my carriers jump on board because, and I've seen it several times where they go, no, you're right, that was our mistake, we'll fix it. And they'll take care of it.
Back when the market was booming and things were like on fire, there turned out to be a lot of search issues or just reporting issues. And
The other thing is our searches are done by people in Florida. And I think that's really important. I'm not just saying that they're done by people in the United States, they're done by people in Florida. Not every agency around here has searches done in Florida, nor do they necessarily do them in the United States. So some of your searches are done overseas and spot checked occasionally by the carrier. And I think that there's a huge amount of risk of getting your search done incorrectly. What's so funny?
Where is your property?
Well, the other nice thing about picking the title company, like in Charlotte County, it's still customary for the seller to pay for title in the title search. In Sarasota County, it's customary still for the buyer to pay for it.
And in Inglewood, it's the buyer too, even if you're in Charlotte County.
Okay, so that doesn't mean you can't,
Negotiate it.
yeah, it's negotiable, it's not a cut and stone kind of thing, so if there's any kind of weird stuff going on, I would always encourage my customer to pay for the title, regardless of which side of the transaction they're on. Actually, just recently, I purchased a short sale up in Ellenton that I wasn't comfortable with the title person over on the East Coast. We couldn't even find her online, right?
Yeah, right?
Yeah. So instead of putting my deposit with them, I told them I was putting my deposit with Kevin, and then they just transferred the money over at the time of closings.
Right.
So
And we looked over the title and stuff for them and things like that. But, those are I would always say, if whatever side you're on, the buyer or the seller side, if you can negotiate it to have it in your pocket with somebody that you know and trust, that you're used to working with, you can build the numbers into the deal and make it work out that way. It doesn't always play out that way, but sometimes it's just easier to know that you can pick up the phone and talk to somebody that you have worked with before, that you know and trust. I think there's something to be said. There's some agents that, they want to call every week and make sure that they can, find out where they are on things. I think there's something to be said also for the point where you get to that, you've done enough transactions with certain parties that you go, you know what, I know that those people at Suncoast One are going to get it done, so I don't have to worry about it. And I know how they communicate. You get it, how you get in that rhythm where you communicate and you know exactly what the style of communication is. That pattern is really good. So if you find somebody you trust and you can control that part of the deal, it'll make your life a lot easier through the transaction. So, all right, so we're on the Schedule A. Okay, everybody see this? This is basically what what title work looks like. In your contract, it always says that you get it. You didn't get one? It's hard to get. I'll tell you.
sorry about that.
So, in your contract, it says, you'll provide evidence of title, right? You didn't get one either? What? Okay.
Slacking.
But I did get 3 copies of the as-is contract.
Oh, okay.
Oh, I didn't get an as-is
Just in
contract.
case you didn't
Did
know.
y'all
I
get
did
this?
get that.
Everybody got a Schedule A thing? Okay.
Thank you.
So when you say title evidence, and some title agents will send you this, some won't. In your contract, it says the title evidence is going to be provided. Do you know what it says in the contract? Anybody?
What's that?
When is title evidence due to the buyer as a standard clause?
The default 30 days.
Oh, it's 15.
What?
15 for finance and 5 for
Oh,
cash.
I'm thinking financing commitment, sorry.
Yeah, you're talking finance. So in your contract, there's a section in there that says basically the title evidence has to be 15 days before closing if it's finance and 5 days before, and that's unless you fill in the blank. Now, as you go into that piece of the contract that says title evidence, I would ask that you don't give me a 30-day contract with 15 days of title evidence in advance. And here's why. Not because I can't get to the title evidence in the first 15 days. It's because when you get a finance deal, we don't like to do surveys until we know that we've got that the loan is kind of going forward. Okay, so that means that we're not gonna necessarily order the survey the first day. We do order the title commitment. Now, there's a survey clause in your contract, and the survey clause also says that the survey will be provided the same time the title evidence will be.
Actually, I thought it was 5 days.
And it's 5 on cash and 15, it'll say, here. In your contract, it says,
It's 9C.
yeah, 9D, I think. Yeah, we will, 9D is about the survey. So, on or before the title evidence deadline, buyer may, at buyer's expense, have the real property surveyed and certified by a registered Florida surveyor. If the seller has a survey covering the real property, a copy shall be furnished within 5 days after the contract's effective date. So basically, they're saying, look, your survey's due the same time as your title evidence, okay? If you're putting us in a 30-day contract and you put us at 15 days to provide the survey and the title evidence, you're kind of putting us in a little bit of a bind. What we're trying to do is have your buyer not pay for a survey if the deal's not gonna fly. So in other words, if your buyer's not getting financed, they lose the deal and they get a survey bill, they're not gonna be happy, okay? So what we try to do is we wait a couple of weeks before we order the survey. We like to order the survey, there's a few reasons. One, we've negotiated a really great rate because we order a lot of them. 2, we have a 10% cancellation rate with our surveyors, which is a nice deal. So if we do have your buyer's deal falling apart, they don't get the invoice afterwards. But I am limited to the 10% of my deals. So what we're trying to do is not order them on day 1, because on day 6, all of a sudden you guys are all, you might have a contract canceled because, not because of the title evidence, not because of the survey, it could be because of the inspection. So we're trying to wait till some of those pieces get in place and that we see that financing is kind of going forward, because hopefully by that time, as you pointed out, your financing has to be applied for typically in 5 days, right? If you're leaving all these things blank, this is where they're defaulting to. Okay, so you
shouldn't be leaving them blank.
and yeah, I would say don't leave them blank if you can help it. I like fill in the blank. So even if you're gonna fill in the blank with the default number, still fill them in. But that 15-day piece, on the finance piece, I would prefer if you gave us a little more time and put it down to 5 days or something like that.
Well, one thing I always suggest, if you're going for a listing, make sure you ask the seller if they have a survey. Because if they do have a survey, they might just be able to recertify that. Get it recertified over to the buyer if there haven't been any changes made to the property. So I think a lot of these agents overlook that when they're taking listings. I don't think they're asking for that survey up front. And then as the buyer's agent, they're supposed to give you the survey if they have one within 5 days. And I think a lot of buyer's agents don't think to ask for that either.
Well, we
Ask
actually
and get it.
Ask
Because
and get
what
it.
we've run into recently is we've been told they have it, and we keep asking, and then when we get to a contract and the buyer asks for it, well, I don't know where it is, I don't have it.
Right. So you should be asking for that right up front. If you're taking
Well,
listings.
and when we get the deal in our office, one of the first things that we ask them in our opening call is, do you have a survey? Because it actually says in your contract that within 5 days you're gonna provide it, from the day that you sign the contract. But it also is gonna help the buyer, because we can actually use a lot of old surveys as long as they can certify that there's been no changes to the property since.
What's the, how far back does that go?
There's some guidelines, for the most part, and it depends on which carrier I'm using and that kind of thing, but one says 15 years, but we can fudge. The other one says, as long as it's the original seller, we can use it. So there's some different guidelines, but the biggest thing is in the end, if they can sign an affidavit that says there's been no changes since this survey's been done, then we can use it. Now you, on the buyer side, I would also say that if the buyer asks you, do they need to do a survey, what's your answer?
Of course.
Yeah.
Yeah, because the minute you tell them no, that they don't need a survey,
Yeah.
the fact is then if there's any encroachments, then it becomes your liability. So,
Because how does that affidavit read, Kevin? Because like, if the seller can attest to the fact that they haven't made any changes, well, what if all their neighbors put up fences? Does it apply to that, or just what they did to the property?
It applies to that there have been no changes since the survey has been done. So,
But
I would
surrounding property?
yeah, no.
See what I mean? That's where you
yeah.
get the big, because a lot of times where there's a problem, it's because the neighbor put a fence up.
Yeah, and honestly, we have seen conflicting surveys even. So if you see something that's near the property line especially, I would say, you know what, we better get a survey on this thing.
Sarah DeRosa has a deal right now where the sellers had an original survey that showed the corner of their pool cage was exactly 25 feet from the property line.
Mhm.
The buyers had another surveyor go out there, this is in St. James City. So buyers just had a survey done, 24 and a half feet.
Difference?
No, the new survey says the pool cage is 24 and a half feet from the property line, which is not in compliance with the setback
Oh, wow.
for that area. So this is like a $1.2 million deal that now they're trying to figure out. So what Sarah and I talked about it, she's gonna call the original surveyor because they are in that town and see if maybe there's a difference as to where they measured to. Like, do they measure to the seawall? Do they measure to the end of the seawall? Do they measure to the middle of the seawall? Something like that, that maybe that's the difference.
I had a deal where there was 6 different pins on a corner
I have two in my backyard.
in downtown Punta Gorda. They were as much as 8.65 feet difference.
Didn't you have one where half a house was?
Oh, I have one right now. Yeah, we don't know what's gonna happen on that, but the GIS shows one thing and their survey showed a different thing. So they bought the lot in the middle, on a knee-jerk reaction, and then they came to us and said, look, everything's wrong. And I said, well, did you talk to the surveyor? They said, no. I said, did you just talk to the county? They said, no. So you bought a lot because you saw a picture online. But it is now in our claims department, and honestly, it's not anything about the title or anything else, except for that there is a survey, there's a 9.2 on it, on the loan policy. That means that the carrier is gonna have to figure it out, and they will either defend it or pay the loss, but the fact is that line looks like it's right in the middle of their house. And so, but that's just from the GIS map. Like I said, we don't know which is accurate and how it's gonna
Which
play
as
out.
professionals, you can't ever go by.
No, that's a very
No,
valid point, but,
it's just an overlay.
yes.
Just to clarify, you said, if 30-day contract of financing, what do you want to go to 5 days?
That's evidence, title evidence, which is, it says.
9C?
Yes, 9C is where the 5 days would, that's what you were pointing at, okay, gotcha. 9D is where it goes into the survey, and the survey ties back to 9C, and that's when you kind of get stuck in a bind if you want to be technical about the validity of the contract, which
So
you
you
should.
want C to say 5 days.
Yeah, if you're, yeah. Because a lot of times, you know, the CFPB is saying standards for a finance deal is 45 days, but most of them we're seeing now are 30. And we're getting them done. But when you're getting them done that fast, that compliance with your survey and your title evidence, you're really pushing your numbers to get them all in the right places. So
Is
it's
that
just,
if you don't have a copy of the survey,
mm,
or either way?
I'd say either way.
Because they're waiting to find out, you know, what's going on in your inspections and financing before they have to charge the seller or the buyer with a survey.
Exactly.
But you wouldn't even have the home inspection done at that.
No, exactly. Well, no, it's 5 days before closing.
Well, before closing,
5
I'm
days
sorry,
before.
it was like 5 days after the
Right.
contract.
Even if they do have a survey that's old enough, that surveying company might not still be in business, so
No more
we
than
can't
that.
recertify
Which
it.
which is
Well, and the
true in
truth
our
is, you
area.
know what, on an existing survey, we don't necessarily have to recertify. As long as we can get that affidavit, we can insure it.
So
Yes.
do you have guidelines as to once the survey's done and you get it ready to close? When the survey is done, it goes to you, right?
Yes.
When do you disclose the results of the survey to,
As soon as we get them in, you guys should get them. Yeah, we should email them to you. Because we get an email version.
but do you have a, you know how there's certain deadlines that have to be met, like does that have to be disclosed 3 days before the closing?
That's what we're talking about, is that if you, based on that blank on 9D, or 9C, that defaults to 15 days.
Okay, so
What
that's
I'm
15.
asking is to put it as 5 days, because 5 days before closing, we can say, look, this isn't right, there's an encroachment, or there's no access, or whatever. But we're not always getting that survey that far in advance.
So what happens, and this is specific to me, I bought a house and I didn't get the survey till we were at the closing table, and the lot lines were not, or I thought they were. What, is there recourse for that, or you just blow the deal, or is there?
Most of
recourse
it
against
talks
the
about if you
title
look
company,
at-
Which was not you, obviously.
No, but if you look in there and read that survey section, and you can tell yourself exactly how it applies to you, but that's in 9D. And there's some other sections about the survey. I think it's, oh gosh. And it basically says if it's not satisfactory to you, that there's some recourse. It's on,
Okay, I'll look at
it's
it.
on line 391 on page 8.
Okay, I'll look at it.
Talks about but it has 5 days to correct and things like that. So, especially if there's encroachments. But as far as not being where you thought they were, I don't know. You'd have to read through that and see if it's all right, so real quick, I want to go through this because I want you're going to get this in an email from us. And the things that I want you to worry about are not the things that you usually worry about. So on the first page, number 2, under owner's policy, it's going to list the name of the buyer. Okay? Make sure that it's your buyer. Make sure it's right. These are the things that people don't think about. They look at some of the things that they shouldn't have to worry about. Number 2, is the sales price correct? Because that's the amount of insurance we're issuing. And this is actually hopefully a trigger for you. If you negotiated and amended your contract and changed your sales price on the contract, then you should have let us know and sent us a copy of the addendum. Sometimes we don't get that stuff. And when you give it to us the day of closing, then it causes a problem. Then we have to redo all the documents while you're sitting at the closing table with your buyer or seller. We get embarrassed, somebody else gets embarrassed. We don't, we want to avoid that. So give us the addendum ahead of time, but look and make sure we've got your things correct, okay?
Should the correct owner be, if the owner is a trust, should that be on there?
If that's who's gonna buy it, yeah. Yeah, you're gonna have that information correct. And that's the other thing, is like a lot of times all of a sudden it'll be like, okay, yeah, this is assignable, or we amended the contract and it's not gonna be me, it's gonna be my trust or my LLC, or now it's not just me, it's me and my wife. Well, we need to make sure that we've got that information. And if it doesn't match, call us and at least ask us and say, okay, yeah, you know what, we've got it fixed, don't worry about that, we've got it. But these are the things that you will know better than we will, that you should double check us on. Next part is the amount, the loan policy, same thing. It would have the amount in there and see if that's correct or what the loan amount is and those kind of things. Those are things that we can change, but just check us on it, make sure. Okay? And then the title up to the estate in the interest of the land. This is the seller. Okay? Now, the one thing that happens the most is that the seller that we find is not necessarily the seller that's in your contract. Think about that. The seller that we find is not necessarily the seller in your contract. It's that fourth person listed on the deal that you don't have a contract from. It's the fact that you went by the tax records. Is the tax records the real landowner records? Not at all. Okay? So the tax record shows who pays the tax bill. Should it be the person that owns the property? Yes. Does it mean that it's necessarily correct? No, what we're going to is we're going to the deeds. And the chain of deeds is going to tell us who really owns the property. So if there's a fourth person on there, if there's a trust, if they transferred it to their LLC or to their trust, that's where that's going to be listed. And so,
We pull up a property.
That's it.
can we pull up a property?
This is your great. So each county has a property appraiser, right? And then each property appraiser has a website that you go on and search for property. So what I'm going to show you in Charlotte County is just
Let me show you this though. This example right here, this is a real live example. And this seller is not even close to what's on the property appraiser website.
That was a mess.
This is a total mess because it ended up with properties transferred into trust, and they died. Oh, and the trust was created with their will, and the successor trustees that were listed are also dead. So when you get back into it, the reality of it is this is gonna say this is who the real owner is. And the big deal about that is, if this is not the same thing that's on your contract, how good is your contract?
Or in that case, if you had the listing, how good's your listing? So you might be trying to sell a property that you don't even have the person authorized to sell.
Right,
So this is-
exactly.
So this is like a property downtown Punta Gorda that actually I used to live in.
Okay.
But, you can see the name of the owner is Jane and Rentals, so it's some kind of a partnership. So this is where Kevin's talking about, they're not relying on that to say who the seller is. They're gonna go into these transactions, right?
Mhm.
And this is where you got the link to the deed that you can pull up, and then this is where they're actually gonna find out who the proper seller
So
of
this
the
was
property.
granted to J&N Rentals right there. But then again, sometimes you have a scenario like this that is really unique, that it's not even gonna be in the deed because it's gonna be in the probate courts.
Well, and especially with trusts, because of the way that Charlotte County abbreviates it so badly.
Yeah.
A lot of, like, as a listing agent, when you get an offer from somebody, it's like they copy and paste it from the short abbreviation, but you need to go into the deed to see, because it's typically gonna be Brett David Bishop as trustee of the Brett Bishop Family Trust. I mean, it's got, and that all is officially the seller's name.
Correct.
So as a listing agent, if you get an offer, it's a good point, Brett, you get an offer from another agent.
It's like a travel.
There's a lot of bad and lazy agents out there.
Yeah.
So you'd be surprised.
This right here, this is another thing he was talking about. This is the long legal. It's from the deed, right? Well, in the property appraiser's website, one, they might have mistyped it, but there's a short legal. Don't use the short legal. It's not worth a darn. It is an easy reference point for them for searches in their computer system, but you need the long legal on your property, and you need to make sure especially that if there is multiple lots in this transaction, that when you make your offer, that contract includes all of the lot numbers that are supposed to be on there.
And their legal description.
Yes.
And especially on any time a parcel ID starts with ZZZ, like your rural property in Punta Gorda and Arcadia, because there'll be the southwest corner of this lot, the northwest corner is.
A stone's through.
Rural
first thing
property,
was
it's
the corner of-
especially important to do that.
Exactly.
Yeah, I've never seen that ZZ.
One day's bull.
And a lot of times they won't fit in the box, like on the contract. You
Right.
might not be able to get the full legal description in that 2 lines. So I just say see attachment A or something, and then.
Or even see additional terms, we can keep it in the same contract,
Yes,
right?
and then I would go into the property record and I'd cut and paste it from the property record into the contract.
But I especially would tell you, warn you over and over and over again, make sure that if there is more than one lot, that it is on your offer.
Because that comes up for you often,
I have
right?
one in litigation right now which basically you have, a buyer and a seller that are suing a buyer and a seller's agent and a broker. Because in the end, it didn't get transferred properly. Of course, we don't know, because this is what was on the contract. So we did the transfer, and then the buyer went, wait a minute, this is supposed to be both lots. Now, nobody caught it before the case. We go to correct it, and the seller was like, yeah, we'll be in. Oh, you know what, no, I didn't really mean to sell that other lot with that. This was the way the contract was written, it was exactly the way I intended. Yeah, and so,
Well, but it happens, because I, you know, especially dealing with a seller who's he's out in Austria, and he's got a bunch of lots for sale, and a lot of them are double lots. He wants, 13,500 for each lot. And I get offers all the time for, well, we'll take both lots for 13,500. And it's like, that's not the way it's gonna happen.
he wants
And that-
35 each,
Right, and it can get very,
right?
it can get muddy fast.
Well, and honestly, I don't know what your original intent was, I know what the buyer thought he was getting.
Right.
And in the end, you got two agents that are stuck in litigation, and they're not suing each other, they're just getting sued by their customers. And in turn, so is the broker.
And Debbie Randazzo had a deal out in the Ranchettes where the listing was for 2 lots in the Ranchettes. The contract showed 2 lots on the contract, and then the seller wanted to back out of the deal because she thought she was only selling 1 lot for that money. Well, down here on page 1, where it talks about time for acceptance,
Section 3A,
the contract didn't get fully executed by the date on that acceptance, and the seller got out of the contract because of that. So that's why it's so important to make sure if you don't get the contract executed and delivered either to you or to the other agent by that date, you need to change that date because
need to amend
once
that,
you go
have it
past
signed
that
as
date,
well.
it's a void contract. It's not a contract anymore.
Jim, on that note, one thing that I think is troublesome to me is the extension addendum for our contracts apply to every date in here but that date.
Oh, really? Well, we should request.
Yeah, I mean, it should be like a petition or whatever to FAR to change that.
Yeah, but you can just cross that out and change it to
Yeah.
the date that everybody signs off on it, but that was something that they changed on the contract.
What's an
within the past
acceptable
couple
amount
years.
of time, Ken? What's normal?
What I usually say is talk to the agent, the listing agent, and say, how much time do they need to respond? They might be on a cruise, or might be in the hospital, or, I would wanna find out. But normally, I would probably, say about 2 days, I would say.
The trick is that it's a negotiation tactic as well. So
I
sometimes
usually
you're
see 1 to 2
shortening
days, but
Put some
like you
pressure
said,
on
if there's a
the
seller's
buyer.
agent.
Before I even sit down to write an offer, I call the agent, one, to let them know that I'm writing an offer, and that gives them the opportunity to tell me if there's anything special I need to know. And I'll ask them, is your seller local that we can get a quick response? Or if they're out of state or whatever, then I might need to give more time.
It also depends too on like the house, the property, and your buyer, because if you've been working with a buyer for 3 months and they keep missing out on deals,
Right.
and then all of a sudden, Thursday afternoon, this house pops up that's perfect for them, but they're planning on having an open house over the weekend, you might want to get an answer by and in those cases, I say, I want an answer by 4 o'clock on Friday.
Yeah, we'll let the time.
Yeah, because I want a chance to try to work out the deal before everybody takes off for the weekend. So sometimes the circumstances will dictate how much time you want to give.
Anyway, so that's a big piece about the ownership. That's not necessarily gonna line up with what you have. It is a red flag for you. It is not something to call us and tell us to correct it. It's something to call us and ask us about, because you will have to probably correct it on your contract end so that you have a valid contract. And that's kind of important. So, the next piece is that legal description. That is the piece where I say, make sure that it matches your long legal, okay? Especially, always check your lot numbers. We even had a deal where we sold the empty lot for $350,000 instead of the house on the lot next door. And it was all because the contract is written incorrectly. And honestly, we only can go by what's on the contract. We have no physical knowledge of the property. You guys do. And luckily we were able to fix that after it started going through the process. But the reality of it is we had the same owner on a joined property, with the same parcel ID, because it was combined, but they named the wrong lot number. So always check that kind of stuff, because that's the stuff that you have to be on the lookout. It's hard for us to catch.
I noticed just yesterday on a listing, when you pull your listing, when you're doing a listing and you're pulling the record from the public record, it very often will pull everything over but the lot number. So on the very last part of it, it's like, oh, it doesn't say 111 or 115
Yeah.
or whatever. And so it's got everything but the lot number, so it looks like you're selling the whole block.
what Kevin's
coming out of the
referring
MLS.
to is, so on the property records, you have a short legal.
See, some people use that, don't do it. Use the.
Now,
long
do you need, I've been told that,
Uh-huh.
like, you might not need all this because this is more for surveyor purposes.
I would tell you that I would, if you can cut and paste all of it, put it in there.
Yeah, cause they're reference to the book and page in the plat map.
Exactly.
Now, see, that's a prime example right there. The short legal does not pick up lot 8. You
And
just
there's lot 7, that's what this last number is, that's
Yep.
lot 7. See this? Lot 7 and 8.
Yep.
So.
And from your side, all you see is lot 7 is, how are you supposed to know that it's both?
Right. Now, the other thing is, I will tell you that if you know that stuff, check us. Because sometimes my searcher will miss it, because they go straight to the deed. And if on the deed, there was only one lot, not both lots, and there's 2 different deeds they should have looked at. Now, we're on them all the time trying to catch this ourselves, but if you know it, you should look at it too. If you know there's 2 lots, this is one of the biggest mistakes that's ever made, honestly, it happens all the time. So look for it.
So especially when you're taking listings, because you don't want to be responsible for not properly listing the property in the MLS and then.
Yeah, that'd be bad too.
So like your case that you're talking about with Randazzo back in the day. One thing that might help identify that is the fact that now, which may not have been the case then, is we're supposed to, by MLS rules, have the seller sign the data entry form.
Oh, I think that's always been the case.
Okay, but then if it had been done in that case and the seller signed off on it, wouldn't they have some culpability?
I would think that you'd have an arguable case, but then you just pick where you go.
Yeah, I think we had an arguable case anyway, because I think the conduct of the parties.
Showed
the
intent.
that signed, yeah, their intent was to sell. And then I think the seller just got cold feet, but just the fact that date was missed, they went to Roger Miller at Far Law Firm, and Roger said he thought they could get out of the contract because of that, which I talked to Ernie Sturgis, and Ernie didn't agree with that, but they weren't gonna go to war over $40,000 lots.
Well, that's it. There's some things you could fight and see who wins, but.
But that's important that comes up because there's an agent I dealt with very recently who just absolutely flat out ignores the time for acceptance date.
Mhm.
So, you have to
Well,
keep
the old
extending it
days-
until they abide by it.
In the old days, it happened all the time because it said that the parties, I think the buyer may cancel if not accepted by such and such a
Exactly.
date.
It basically
For
says it's
withdrawal.
offer is null and void.
Now it's.
But I would think, and of course, I'm not an attorney, but I would think that if the buyer says, my offer is null and void by this amount of time, and then they both end up signing afterwards and they move forward, that it's the buyer's ability to pull out, not the seller's ability to pull out of the offer. Because it's an offer and acceptance. Once you got the acceptance and the signature, isn't it past that date? Isn't that, I don't know.
I agree. Logically, that makes sense to me. If the seller signs and the buyer says, okay, well, fine, then yeah, I'll still go with it. When the seller signs, they knew what they were doing.
I'm telling you, we read what it says. It says. it's
Yeah, no,
null and
I
void.
agree with you. I agree with you. I know what it says. It's just, yeah.
Well, it says it's done by this time or is deemed withdrawn. So that's on the buyer's side. That's why I say it that way.
Well, that's-
And I agree
it's
that it
telling
can
what
be
Roger
argued,
Miller said, yeah.
but nobody wants to go to war over a 40. Well, some people would, but I kind of get where that was coming from. All right. So anyway, this is the rest of it though. Section 1 on Schedule B. These are all of the things that we have to do as a title agent to get to the point of closing date. This is where people really get nervous because they see all this stuff and they don't realize this is stuff we do all the time. So what we'll usually do is we'll send out this and we'll say, here's your title evidence. And then we'll say, look, you know what? Everything looks pretty easy. We'll take care of it. Or we'll say, look, number 4 is a real problem. And I'm just picking things out of the blue. But, whatever, we might have an error that we had to find that might cause a trouble. But that's a rare occasion. If there's a problem in here, or if there's something significant in here, we're usually gonna tell you that there's a problem. But beyond that, these are things that we pick up all the time. We need this corrective deed, we need this trust, and honestly, if you look through this one, this is all about dead people and trusts and quitclaim deeds, everything in this search. And it's all about those things. And then the other piece too is, if you hear the term power of attorney, let us look at that one too. Because power of attorney might not be valid in the situation that they're in.
Well, because there's a lot of different types of power of attorney, right?
Correct.
And there's only one that applies to being able to sell real estate.
It has to specifically say the right to buy, sell, or otherwise convey property. The other thing is, a lot of people think their power of attorney will work for their wife's trust, which it doesn't. If it's a trust, then the power of attorney is invalid. It's about who's the trustee. And I think it doesn't apply if the person.
Medical. If you have the power of attorney, it could be a medical power of attorney.
Right. You know what? If it has to say Florida or not, I don't know the answer to that one. That's an interesting question. I guess I should know that.
Some attorney told me at one point.
Yeah. But a big piece of it is some of them do not specifically say that you can buy or sell real estate on their behalf. It'll go through all of these things that they can do financial transactions on my behalf and things like that. A lot of times around here, it's about medical or somebody that's in nursing home care and that type of thing. Those are things that we are looking for, is those specific powers. The other thing that we're usually honestly looking for is the person that granted the power of attorney. If we can, we really like to talk to that person and make sure that they know that their stuff is being sold. So if they're cognitive still, we want to, because there's a lot of fraud in power of attorneys too, especially with elder abuse and those types of things.
Yeah, Nancy Weber just had a deal. She listed a house. The lady called her up, listed the house. She listed the house, went under contract, and lo and behold, what happened was she forgot she claimed the house to her son a couple years before. Guess who didn't want to sell the house?
Oh, wow.
Shocker.
Wow.
Yeah, so Western America. Nancy's been doing this for longer than I have, and
Yeah, I mean,
well, it was never they never changed the name on the property record.
on the tax record, so you wouldn't know. But again, the tax record's not the real deal. So even if you quitclaimed it and the county didn't catch it in the tax records, doesn't mean that. Yeah, exactly. So
I will say though, with the title search results and everything, don't try to be the title expert and explain everything to your customer.
Yeah,
Get them
stay
in touch
in your
with the
lane.
title people. Let them talk to each other.
yeah, let us do it. That's why I say get us involved early if you think there's any kind of hitch. This thing right here where it says owner, this actually should just say taxpayer, because that's what it is. Not necessarily the owner. They're trying to get it right, but and they're better at it than they ever have been. But in the days of computers and stuff like that, but back in the day, even 5-10 years ago, they were still struggling to get the owners right. They didn't have a real understanding of how people were using it in the real world. They just worried about who was getting the bill and if the bill was being paid. So things have changed. Okay, so that's what this thing is about. This talks about all the successor trustees. If you can look through A, B, C, and D. This is actually one that's kind of a little ugly. It talks about a deed from the successor trustee of the trust of the benefit of this person created under Article 8B of the last will and testament. So think about that. All of these people, these are the successor trustee of the trust for the benefit of, created by the will of. There's a whole chain of dead people in here. And this is the kind of thing that I'm talking about that we have to clean up and find the right people to sign off on the right deeds. Okay? And then you've got D is funny because you got the deed from this guy, both individually and joined by his spouse if he's married, because we have to find that out too. And the recitation of the non-homestead clause, because if they're married and they live there, then both of them have to sign off on it. And as trustee, conveying the property described. So all of these pieces are all these little things that have happened over time through the death of the owners of the property and the death of the trustees and the successor trustees. So that's why I say let's look for this stuff in advance.
So just something you just said that I don't know. In Florida, if your married couple has their homestead, but the property is just in like one of the spouse's names, they still both have to agree to sell the property, right?
So that's why I say marital status on a deed is important, otherwise it can be a clouded title. And that's why we look at quitclaim deeds especially, because a lot of people don't realize, even if they got the legal description right, did they put the marital status on it? Because if they're single, boom, it clears it off. If they're married, well then is it non-homestead or homestead property?
So I've got a story for that, Melissa. So we're trying to buy the lot, right, or sell it, right? With the handwritten divorce
Oh,
decree.
God, yes, okay.
The handwritten
The
divorce.
woman's like, oh
I don't
yeah,
like you
no,
anymore."
I got the rights from my ex-husband to sell this whenever I wanted to. And she finally, after asking and asking, gets the paperwork. It's a handwritten note that they both signed with no notarization whatsoever.
Well, Christina handled that one for me.
Yeah.
She did an awesome
You
job.
said three
Did I
times.
get it cleaned up?
Yeah, it was sold, thank you.
So see, miracle worker title company right
Yeah,
there.
yeah.
And take
It
a
did
napkin
take
agreement
months,
to make
but-
it work.
It did, but.
Yeah, things can work out, it's just that.
Some take longer
sometimes it
than
takes
others,
time,
and that's where I go back to when you get the listing itself and you see and you hear, just listen for some of those clues, because those are the ones you want to search out now. You want to get the documents now. You want to get as much as you can in advance, because a lot of people think, look, as long as I get the listing agreement done and I get some showings for this house, I'm gold. Well, no, because you could be doing a lot of work that you probably should have cleaned up the mess beforehand.
And that's it, get the documents now, because they say that they have them,
Mhm.
get them and see them, because, it didn't take an expert to realize that wasn't gonna hold up in court.
And then the ex-husband didn't want to, sign, there was a whole bunch of.
Right. Is that what we did? Was we finally got the ex-husband to agree?
Yeah,
Like
I had
in
to
Nancy's-
beg and plead for that.
Like in Nancy's case, the property record was in the lady's name. And then I guess she didn't think to go over here, there was probably a transfer with $100.
Right.
That's probably a recorded deed, yeah.
It's probably a recorded deed that if she had gone into that deed, she would have seen that there was a quick.
And this is where I would go back to you and say, you know what, if you see anything that even, just get us involved. Don't try to do it yourself.
Where are the mobile homes on West Virginia? I'm looking at the current use.
That's
of
what
this
it was
property.
originally platted for back in the day, right?
When, what the hell is NR10? The zoning code.
Neighborhood residential, 10 units per
10
acre.
units per acre.
So the city of Punta Gorda has a very old zoning code, so does Northport actually too.
Do they?
Yeah.
All right, so if I go on to the second page, this kind of gives you some more of the entertainment about this whole deal. Oops, I left somebody's name in there. I try not to do that. Execution and recordation of the current trustee of the trust for the benefit of, created under Article 8 with the last will and testament of a certification of trust in compliance with, blah, blah, blah. In the event a successor trustee is attempting to convey the mortgage property, said successor trustee is not set out on the vesting date. The portions of the trust and amendments setting out the successor trustee should be attached in the trust certification. So in other words, we need trust documents. And you know why? Because we gotta review all the trust documents, because they're not necessarily recorded documents, but there's a section that'll say, this is what they can and can't do, this is who's allowed to do it. And as long as we have those trust documents, and we can do the trust affidavit and lay out the pieces that need to be there, but we have to have a copy of that. And a lot of people are like, oh, it's 40 pages, you don't wanna see all that. Well, honestly, here's the pieces I need. I need the front page, I need the signature page, I need the thing that designates the co-trustees, I need to see the pages that designate the powers of. And you know what, send me all 50, I don't care, because we'll dig through it and we'll make sure we have every page that we need, or we can come back to you a few times and say, nope, we're still missing the page that says this. So you might as well try to collect those documents in advance. They might not be willing to give them to you because they might have financial information in them of like different properties they own and stuff like that. But you can have us, you can say, look, I can have my title company reach out to you because I'd like them to review the pages of your trust that they need to see so that we can make sure that the property transfers easily.
So when you say we need them, you're talking about the carrier needs them.
We need them, yes, this is the underwriter. But we're gonna send them off to the underwriter and say, here's the docs I have, is this good? And they'll say yes or no. And they'll ask us
It's kind of a
for
big
something.
deal that you're handling it that way and you're not allowing some local person who thinks they know what they're doing.
Right, yeah, don't do it yourself, my goodness. And I'm not gonna, and honestly, even in my office, let's face it, I know how to read a trust, I know what they're gonna approve and not approve. In fact, there's sometimes they'll come back to me and say, okay, well, no, we can't do it this way. And you know, they'll start to turn down a deal, and then I'll look at it and go, wait a minute, here's where you're missing this, or you didn't think about it this way, or you didn't think about it that way, and so we can try to get the deal done. But yeah, I'm not gonna rely on just people in my office going, yeah, the trust is good, and boom, we're gonna do it, because if that is a mistake on our part, guess what? It's on us. So send it off to them, I let them say yes or no, and if they say no, I'll fight for you to get it done, and usually if there's a way, we'll get it done. But the big thing is that the underwriter in writing has said, yes, this is valid. Why is that important?
When the claim sticks.
If the claim is out there, the underwriter's paying, because I have it in writing right here, this is where you said it, because you know what happens when a claim happens? They email me and they say, no, it's called notification of claim, and they say, here's a claim, please send us a copy of the file. I have every email, every document related to that file, and I send it all up to them in a packet. And the one that's always, that one email that's always there is the one that said, yes, we approve. You know, if there's certain questions about those things, then we save that always, because that protects us and that protects your customer. So, anyway, this section, Section B, Schedule B, Section B, okay? This is all the exceptions to what's in a title policy, and this is standard language. It's always there. Every search we get always has this. Every policy we get always has this, except that there are certain things that, like number 3, it says any encroachment, encumbrance, etc. Well, if we have a survey and we issue what's called a 9.1 is on a loan policy and a 9.2 is on a owner's policy. But if we have those endorsements on the policy, we'll remove that survey and encroachment issue because we have the survey on record and the underwriters approved it. So that's important. And then the other thing I want you to notice is number 7. Any lien provided by Chapter 159 Florida statutes in favor of any city, town, village, or port authority for unpaid service charges for service by any water, sewer, or gas system supplying insured land. I have customers all of the time, sellers that are going, I already paid it, or it's not your job to worry about whether I paid my utilities. Guess what? For the buyer, it is my job, because that automatically attaches to the property under the law. So I'm sitting there protecting the buyer from an unpaid utility bill that is going to be the seller's, because we don't have evidence that they paid it. So we always do a utility search, and the utilities are always going to be paid at closing. Now, if there's a refund to be had, or they can show me evidence of a paid receipt, we can remove that. But we'll send them their utility payment back. We'll send them the refund back, because they send it to me and we turn around and send them out. But that's a big piece that a lot of people fight us on, that they don't understand why we're worried about whether they paid their utility bill.
Well, and it used to be, when I started my career, we would call the water company and get everything set up. But because of liens and that sort of thing, now it's only done after closing with you guys faxing or emailing the deed, right?
Yep.
To the water, whoever the water
And it
supply
depends on
company
the
is.
municipality. Some of them you have to do them yourself, some of them we can't. But getting that last bill paid is a big part of closing now, which didn't used to be. It used to be in the searches and stuff like that.
So don't almost all properties have some kind of utility easement? Right away?
Yeah, I guess you could say a large percentage of them, you have a drainage easement, utility easement, that type of thing.
I don't think I've seen one that doesn't have a 8 or 10 foot easement on the side property
Yeah.
lines to get back to the power poles or whatever.
Yeah, because it's usually every other property on most properties, I would think. So, yeah, it's probably the case.
So that should.
That's
We've
not a
seen
big
issues where that buyers have walked away from deals.
because of utility easement. Wow.
Not very often, but.
Well, I think
More
it's
than once.
because they think that they can't put a fence up, but they can.
Right. Yeah. And they think that the utility is going to come through and
drive
take down their
truck through
fence
it, right?
and then not
Yeah.
put it back, and that's not usually the case. So, anyway, the big deal is that those are pretty standard things, and some of these pieces are going to talk about grants of easements and stuff like that. But this last page right there is gonna list the actual easements on this property, that are in public record that we found. And then the other piece that we're gonna talk about is when we have a survey, we actually will have a survey document that'll say, basically, here's the call outs on the survey itself of the things that you have. Here's the encroachments, here's the easements. An encroachment is when your neighbor's too close, whether it's a fence, the corner of their house, the pool cage, the shed, or anything like that, that's an encroachment. An easement is when somebody has permission to get through that property. That is utilities, that is drainage, that is road. And some of that, when we go back to the rural properties, then a lot of them are road easements that are granted by the neighbors, or granted to the neighbors, I guess you would say, so that you have an access to the property. The other piece that we will find and we will look for, and you might have to prove, and sometimes it's hard to prove if you're on a rural property, is that you actually have access to the property. Because the seller and the buyer wants access. The seller's always had an agreement with his neighbor that he's been able to drive across that property, but unless there's a written easement and recorded, then you can't necessarily, we can't insure it because you have to have access to use the property.
Right. Or try to get approval to do a flag lot type deal so that you've got access back there.
Yeah. So somewhere you're looking for, we are looking for access to the property if there's a recorded easement and that type of thing. So those are all the pieces that we're looking for through the title search. And we've actually had only I think we had one deal that we couldn't get done because there was no access. And we've had a couple of deals that were bad because of surveys, but other than that, we will get the job done if we can. So those are the pieces that, that's all the back leg work that I wanted to talk about. Then I'm going to talk about this piece with the settlement statement. We have two different settlement statements here. One is the Alta settlement statement, and the other one is an old style HUD. Okay. Both basically have the same types of information on it, but they have notes on here. And the reason I give you this with all these notes on it, these are the things that you should question. You have one, Brett? These are the things, when we send you the HUD, there's a reason we're doing it. We want you to check it before we get to the closing table, and we want you to answer us and say yes or no. And these are the things that you're looking for. Okay, in the beginning, the third box down is the property address. You're looking to make sure that we have the right address. And then is your seller correct? Is your lender correct? Those are pieces that are important. A lot of times when we send these out, if the agent checks them, the only thing they checked was their commission line. That's not good enough, guys. It's really not, because you know what? When your buyer or your seller looks at it at the end and says, look, this is wrong, we've already sent it out to everybody and said, please verify this information is correct, please, because we don't want to get to the last day and have to redo everything. So, or the one that comes 3 days after closing, where somebody said, hey, by the way, this is wrong, that's too late. So then it becomes a real mess to clean up. So, all right, then we get back to the debit or credit, which is the sale price of the property. Please, please, please check. This is 2 or 3 days before closing. Check that we have the selling price correct. So many times people have negotiated a change in price by the time the closing date has come around. And so many times the addendum has not come to us. And we have to prepare the documents and calculate all the numbers based on that. If it's wrong, it's going to take some time to fix it. And you people are going to be sitting at the table. We don't want that to happen. So please look at that, okay? The taxes and stuff, that actually gets prorated by our system, and the truth is, I don't think you need to really check it. If you're a mathematician and you want to do it, we have had one that called me and told me we were a penny off on all of our deals. We fixed it. He was right. Ken Rollins, thank you.
No, I've done a math girl, nope.
No, Ken actually called me up and said, Kevin, I think you're wrong with everything. So we did. We went back to the programmers and got him to fix it. He was right. Okay, so down on the borrower side, there's another circle down there under homeowners insurance premium. Okay, that means that they haven't paid their homeowners insurance premium. They've sent us the invoice and we're paying it at closing. We're okay with that. If they've paid it already, we should be looking for that, because if they have, they would have a copy of a paid invoice, or they'd have a receipt for payment. If that's the case, we didn't get it before closing date, we really don't wanna, again, change numbers at the table if we can help it, because we have to go back and redo things. Okay. The other piece, impounds, that's all about escrows. Okay, so where your lender is escrowing for taxes and insurance and stuff like that, and they like to collect a little in advance. Then the next page, we go on to, okay, this is our closing fees, okay? On this one, we basically, the way it's drawn out is the seller's paying, that's why there's numbers on the seller's side. There's our closing fee, the title insurance premium, the search, okay? If it's on the seller's side, make sure your seller is supposed to be paying it. If it's on the buyer's side, make sure your buyer is supposed to be paying it. Just check us against your contracts and what you thought the deal was, because we're looking for a second set of eyes that, you know, we make mistakes, it happens. Not often, but it happens.
I'll just go back to the idea about having your customer pay for a title instead of just go on with the flow. That house I brought up in Ellens was a short sale, and the title person they wanted to use, or I offered to pay for title. Well, the fee, the closing fee that I ended up paying was like $1,000.
For the buyer's side.
Yeah, because, yeah. So that's the other thing we see a lot, is if you let them use some law firm out of Miami, or the East Coast is notorious for
Title mills.
these crazy fees.
For the buyer's side, where the seller's supposed to be paying title,
Yeah.
and the buyer pays the closing fee. Even on a cash deal, and the attorney or somebody over there is paying, charging them $650 or $1,000 for a closing fee. When, in my interpretation, if the seller's supposed to be paying closing, there shouldn't be fees to the buyer. The only thing we charge is if there's a mortgage, because there's a 80 to 120 page document and a lot of work to go into with them, but that's just to close the loan, not to close the property.
So just be aware of that. You'll see some crazy fees from some of these places, which can almost more than offset the cost of the title in some cases.
Well, and really the red flag is if I'm doing anything on the West Coast and the East Coast title company or law office pops up, I'm almost 100% gonna be paying fees I shouldn't be.
Right.
Yeah, you're right.
Unfortunately though, if it's a short sale or a bank owned, the odds of you changing their mind are slim to none.
Especially on bank, yeah.
So the other, this is actually my favorite part of this thing. See that commission line where there's a blank? Now this is an actual example that an agent sent back to us that said approved. That's the one line that most agents
Pro
check.
bono?
We missed putting their commission on it, and they didn't bother to look at it close enough to even notice that their commission were on.
They had so many classes with you that you drilled it into their head, look at the other stuff, not your commission, so that's
I didn't say don't look at your commissions. I just said don't only look at your commissions.
I figured they owed that to you, right?
Yeah. So anyway, they were gonna sell this for free, so their sellers didn't owe them a dime. But we did end up actually catching it and saying, oh, wait a minute, there's no seller's commissions. You sure you reviewed this settlement statement? And they looked at it again. So, anyway, so this gives you your bottom line. Some of the things down there are some things that are special notes, things that you should look for. If you negotiated seller credits to the buyer, make sure they're in there. Okay. If you negotiated a home warranty, or it's supposed to be a home warranty and who's paying for it, that's something that gets dropped a lot because nobody told us, or we didn't get an invoice to pay. Sometimes it gets paid outside of closing. We need to know that, but those are things that you should look for on your settlement statement to make sure. Again, and this is another one, realtor credits. Did you tell your seller that you would pay X because they were fighting over a water heater, and you're like, heck with it, I'll pay for it, I don't care. Those types of things, we don't know about those. Make sure you check for them. And then, of course, make sure we didn't forget your commission.
I had a situation recently, and this was with it was a builder that was buying a lot. So they used their title company up in North Orlando. And when this came out, there was FERPA withholding,
Oh,
because my seller's farm, but it's owned by a corporation in Florida, so I had to call them and go, no FERPA withholding, this is a Florida corporation, even though the owner of the corporation is a Florida.
right. We've been through that one, huh? Yeah, I think I remember that one, John.
But if you are giving credits for repairs or credits for closing costs or whatever from your commissions, you probably need to clear that with, if there's a mortgage involved, you probably need to clear that with the mortgage.
Yeah, you know what, and honestly, if it's on there, what's gonna happen is we go back and forth with the lender already, with the closing disclosure and settlement statement and stuff, and they'll see it. If they're gonna disallow it, they're gonna tell us, they're like, no, you can't put that on there.
I just, at Toby's class this morning, I proposed that to her because a couple years ago, we had a deal where this great young couple wanted to, buying their first house, and they couldn't get all the gift money together, and we wanted to give our commission to make it work. And we couldn't because we were directly tied to the outcome of that, right?
Mm-hmm.
What Toby said is that we could have drafted a commission agreement with the seller to reduce our commission, and then the seller could take that to apply as a seller contribution,
Oh, that makes sense.
which I didn't know.
Yeah, that's a good way to do it.
And that way the lender's okay with it.
Right. Yeah, that's actually a good way to do it. Anyway, the other section, the other pages that are on there, that's the old HUD. A lot of people are not gonna see a HUD ever again. Occasionally, you'll see one with a cash deal or something like that, because the old HUD one is done away with. Most of the time, we're going to the settlement statement now that they've integrated them into our system so well. But I give you that for reference, in case somebody ever sends you a HUD and says, check it, you have some notes that you can go back. It's the same kind of thing that we just talked about with the settlement statement. Go through, make sure not only your commission, but check your credits, check your home warranty, check your selling price, check the seller and the buyer. All of those things are pieces that you can make sure and verify for us, so that we don't get caught at the table and we all sit there and go, oh geez, so we should, it's never good when the title agent looks at the realtor and says, we never got an addendum. We didn't know you changed the sales price. So even if you think the other realtor sent it to us again. If we get it twice, we're not gonna be mad. And I would tell you, if the other agent is telling you they're gonna send it, don't believe them anyway. Don't believe them anyway. Not because I think that they're, bad or evil, but if somebody gets busy, somebody forgets it. If we get it twice, great, we already got it, no problem, thank you. We appreciate it. But if we got it 0 times, that's even more fun.
Kevin, I've run into, with other title companies, if a realtor wants to reduce their commission for something, or, provide a credit out of that commission, that they absolutely will not do it without seeing a letter from the broker.
Well, that's because, broker's got to authorize it.
Right, so, but, I mean,
Would it be on our DA?
it would be in the DA by the time you get it, but I think in this particular situation, we had already known so far in advance that they just wouldn't do it, so they had to wait for the DA to come through before they would do that.
I don't know that we've ever got into that scenario where we've worried about whether to me, it's kind of between you and your broker. And
Somebody had a deal the other day where the buyer's agent was the mother. It was the buyer's mother, who was also the agent. She didn't want to take her commission. She wanted to let the kid use it for closing costs or whatever. And so my first reaction was, well, she has to get permission from her broker to do that. But then the thing was, also, is the lender going to allow that? So what we ended up doing was, we ended up recommending that the seller would grant them a credit, what was equal to the buyer's agent's commission,
Right.
so $6,000, I think.
And it reduces commission to the.
And then we had an agreement with the seller that we would reduce compensation to 3%, so we would get paid our 3%. And then we had an agreement with the other brokers saying that they would waive their co-brokerage on the deal. Because think about it, we have a listing agreement with the seller that says 6%, 3 of it's going to that guy. This guy's, because he's a member of our MLS, has the right to that co-broker that's advertising the MLS. So we need to get that cleaned up. And then where ultimately does the money need to go? Now it's gonna come from the seller instead of the mother.
I get that in terms of like an entire commission or a half a commission or something like that, because that's a disservice to the broker and brokerage itself and needs to be agreed upon. But in this particular case, it was like $200 towards a dishwasher or something to get the deal done. And I've never run into that with you or any other title company except this one. And it just
I would
wouldn't
tell you,
work for us at all to get it done.
Our deal is to get the job done. We are not here to police your contract for you. So, if you tell me that this is the way the commissions are supposed to run, for the most part, I'm gonna agree with you. You're gonna have to duke it out with your broker if you mess it up, and it's definitely not on us. There's certain things, like I always say, the other part of it is like escrows and things like that. I'm not here to police this stuff. I will report everything that's going on. If your escrow deposit comes in, I will tell you when it's there. If you haven't heard from us by the date it's due, you better be talking to your buyer and say, why have you not put in your escrow deposit? Or if you haven't, if you have the seller's side and you still haven't gotten it, because we send it out to both sides, you should be checking and making sure, why do I not have an escrow deposit in on this deal? We as the escrow company are the independent third party. We're not here to police things. We're here to do things. So I don't know that I would ever check on a commission.
Well, and like you said with escrow too, I think that's one that comes up for brand new agents just because they don't have the experience of it. But, if I put that person down, put down Suncoast One as escrow, some of the new agents assume that because I put that on there, that you're gonna be hounding for the escrow, and it does not work out.
No, it's not.
So if I'm the listing agent on a property, and the escrow is due from the buyer in, say, 3 days, and it's not there, and I should be letting my seller know, look, the escrow is not there, instead of just letting that time frame go by.
Well, you should be on the buyer's.
Well, we should be on the buyer's.
You should be on the buyer's agent and say, hey, you guys, we don't have any evidence.
Right.
And we'll get a phone call and be like, on the beginning of day 3 and say, hey, we haven't seen a receipt for escrow, did you get it?
Right.
And sometimes, we sent out a receipt and it went in your spam filter or something. But a lot of times we'll be like, no, we didn't get it. And the seller's agent or the buyer's agent, but the seller's agent should be making sure, because you're falling out of contract, and go after the buyer and say, or go after the buyer's agent and say, hey, your buyer has not given us the deposit back. They need to get it in by the end of the day or we're out of contract.
And I think sometimes agents, whether it's lack of experience or lack of education, whatever, look at the escrow period at kind of the same as that time for acceptance. And they don't realize that contract is done if that escrow is not in.
Well, and the thing is that if you're not keeping your seller informed as to what's going on,
Yeah.
and then all of a sudden the deal's going along and the escrow's still not there, and then it dies for some other reason, you might be coming up with some cash to give
You
to
might have some
yourself.
liability yourself, yeah, so.
And that's not what if. That's happened.
Yeah.
There's been a dispute, seller wants to keep the escrow, and the escrow never came in.
Well, and the other thing I always wonder about too, I don't think I've seen this, but, okay, so I'm the buyer's agent or the buyer, and my escrow doesn't get there on time. So technically, I'm in default, right?
Mhm.
So then I get it there a day late or 2 days late, and then the money's there now, so what's the harm? No harm, no foul, right? Then all of a sudden, something goes sideways on the deal.
Then you get a
Can
lot
the
of
seller make
questions.
a claim on my deposit? Because I've been in the fall since that third day?
And realistically, that would be the case, right?
They could, you would have
No,
arguments
because
all
it's
the
under-
time.
because it's already there.
And I'm not a.
But it got there late. They were out of contract.
Yeah,
But it's there now,
here's
so
the
if
thing.
you back in,
If,
it's
I
normal.
guarantee you, if time for acceptance was what it was, that one surely would be
Right,
a
so my
claim.
point is,
Here's the
That's
thing, the
operating
contract is
in-
voidable, but it's not invalid.
Right.
So essentially it falls upon, since the escrow was accepted late, essentially now the seller who's accepted the escrow hasn't waived any of their other rights under the contract. So they have the ability to cancel virtually at any time. Anyway, the buyer loses their leverage.
right, but I
Again,
guess,
it's all
Yeah, what-
subject
what
to
happens is-
particular
Yeah,
interpretation.
if you don't get your check in on time and he's got a potential backup offer,
Oh, yeah.
that's better,
Well, that's absolutely.
you know, sorry,
that's the part,
dude.
so that's my whole point though, like the acceptance date, the deposit date. I mean,
Time is the
I think
essence.
sometimes we take all that too lightly
Yes,
and you're just leaving a little gap open.
for a reason for argument, which
Yeah,
is a
reason for
reason for
argument, exactly.
litigation, which is a reason that something could collapse on you.
And
If you get every piece in on time perfectly, then you will close all those little gaps and you won't have a reason for argument. Who wins the argument, that all depends on the courts, and it always does.
A lot of
it can
times,
even be behind something that happens behind the scenes that you're totally oblivious to because you went under contract and your seller's best friend said, "Oh man, I was gonna buy that from you." So now he can't wait for it to fall apart.
sure, or they might have found out they could have got more money from somebody else, so.
Right.
Yeah, so just don't leave, try not to leave that gap open, and if something happens unexpectedly that's gonna prevent you from complying with the terms of, your customer from complying with the terms of the contract,
And then,
get in touch with somebody and get an extension or addendum or whatever you need done. Don't,
Keep track of your dates.
yeah.
There's a lot of software out there, Gmail plugins that can help you always keep track of those dates.
And agents are notorious for like their texting or they're working things out on a phone call but they won't follow up in writing. Whether it's an email or an actual document that needs to be executed, you know, those text messages and phone calls aren't gonna save your butt when the E&O claim comes in and we've gotta supply the E&O carrier with the package. We need documentation.
That's correct. At the same time, I will tell you, arguably, if you are a very good note taker with dates and times of phone calls, and you can show evidence that you've done that in all of your files the same way, those notes will carry weight. Okay, even though you haven't gotten this stuff in writing all the time, but that's a big piece that we've found in our business, that because we have a very specific note system, our notes can be used as evidence. Doesn't necessarily mean that it's always gonna win, but it does mean it carries weight.
And honestly, like you said, that you do with your deals, you save every email. That's something that we personally do in our business, something every agent should do. Technology has made that super easy these days. And even text messages, if you have text messages at all throughout a deal, share those text messages to your email, and then you have a record of it that you can record and file away digitally.
And then put into DocuSign or whatever.
For storage.
So that's that piece. We do have the contract, we can talk about that a little bit. There are some pieces we've kind of covered. Do you want to go into it, Jim?
Well, I was just gonna say the same thing, that there's some clauses in the contract that specifically relate to the title, right? So we already made reference to 9C, so did you guys follow what Kevin was saying? He'd rather you not leave that blank and put him in a 15-day prior to closing situation, he'd rather.
15 days is fine if you're giving me a 45 to 60-day close, but if you're giving me a 30-day finance deal, and you want the lender to get it done and us to get it done, and
If you're doing a 30-day financing deal, you better have talked to the lender, find out if they can do 30 days, right?
right, exactly.
So, first of all, your customers should be pre-qualified before you're taking
Even
it
better
out
if
and
they're
showing them.
pre-approved.
Yeah,
Even
pre-approved
better
is
if
even
they're
better.
pre-approved.
Pre-approved is
can't
better.
go with that.
I want to know about 2A, because whatever gets put into 2A is who's closing the deal.
Okay,
Stop it.
all right. So 2A, Brett's talking about the escrow agent. So you can put the money,
Page one,
that's not the person that's closing the deal. That's just the person that's holding the deposit.
right. So
So,
that escrow agent information, first of all, it's Suncoast One Title and Closings.
Right.
it's right
But
on your little card, isn't it?
yes, absolutely. And the fact is, if you turn that card over, there's like the address and all of that stuff right there for you, the address and phone number. Now, the big deal about that is a lot of, you're gonna have a couple of things that push back. Obviously, those of you who've been in this for a while, you'll know. One, TBD is not valid. That's not legal, that doesn't work. Okay?
Unless it's Title Bureau Depot and that's
Yeah.
their initials.
So if the seller's gonna be paying title, you should be talking to the other agent to find out who they plan on using for title.
Either that or just fill that in with our
Yeah.
name.
That's what I do.
Send the title, send it,
I'll fight right back with them.
send the escrow to us, we're okay with it, and the fact is that if it gets to, I mean, part of it might go back and forth right there with negotiating, and they go, no, cross that out, put a different, this title company, whatever, and we'll initial it, that kind of thing, but putting that in there, one, gives you a chance that some agents don't care where it goes, nor do their sellers, and you have a chance to control it even if you're not paying for it. So even if your buyer's not gonna pay for it, you put your title company in there, the one you want, that'd be Suncoast One. But you put that in, and there are, 20-30% of the time that they'll actually accept it because the other agent has no skin in the game, they don't care.
We just had one go that way,
Yeah.
okay? I mean, that's something that our team does. We always put you down for the escrow, and that seller nor the agent particularly cared, and so it ended up closing with you, which was great.
The other thing too is I never take deposits anymore with offers, like take a check.
Right.
At the time I submit the offer, I always usually put 3 days after acceptance, because I don't wanna be
Right.
having to send somebody's check.
Only time I do is if I can tell that it may be a multiple offer type property. That's the only time I will, just to try to strengthen the offer.
So then you
That's
just
very
show a
rare.
copy of the check and
Yeah.
stuff that you have it.
Yeah.
That's
But
interesting.
then I'm getting it right to your office as soon as possible,
Right. Yeah, because how soon do you have to get rid of it?
as soon as possible.
So
It's supposed to be to the broker within 24 hours, and it's the escrow agent within, I think, 48
well, it's,
the 3
you
days.
basically have till the end of the next business day to get it out of your hands and in the broker's hands. He has until the end of the next business day to get it in.
So you're just saying bring it to Jim and he'll handle it.
Yeah. I think what Jim's gonna say is,
Super.
don't give me that check.
I like that.
Let's get done at a time.
We don't hold escrow.
Uh-huh.
We have a Suncoast One cookie jar that we put the checks in, and then Jim takes that cookie jar with him.
Just pulls them out whenever,
Try
you
something
know,
different.
once a week or so, you know. But the fact is even if you aren't ending up closing it with us, we don't mind holding escrow. So that's, like we did with Jim's deal. You're welcome to put the escrow with us. This is not defining who your title company is, it's defining who the escrow agent is. And basically, we will send the money to whoever it needs to go before closing, and that's it.
That being said though, give you a contract
Mhm.
with that escrow deposit,
Yes,
and then you're not policing when that escrow needs to get delivered. It'd still be nice if we
You-
let you know.
oh, you still, yeah, when it comes to closing date and things like that, you're getting
Yeah.
close to closing. Typically, the other title company or you should be letting them know that they're ready to close, because we don't know when you're really ready to close.
Because you're not actually going through the process, so those dates.
The title company, usually, the other title, because I've had it happen before where I've deposited with you, the other party said, no, we don't need our. And then that title company will reach out to you, they'll ask me, where's the escrow?
Usually, so
They don't always though.
there's a few title companies that are looking for reasons to be mad,
Mhm.
and they'll blame us for not sending it to them. It's like, you didn't ask for it, so.
But you'll learn
We don't
that-
even know where it's closing, honestly.
Right.
So if you put it on deposit with us, we don't necessarily know where it ended up going until we get the request from your seller to send it over.
But it's nice to be able to tell your buyer, like, hey, we worked with them, I'm putting it with them. Even if they decide to close somewhere else, we know your money is safe.
Mhm.
You know what I mean? In the meantime, and just put it in there, know where it's going right away, and then again, like you said, you don't know if somebody's shady or not on our side, if it's on the other coast. So, if we can say, listen, I put the escrow check with Kevin at Suncoast One, we know that they're good. If something happens, it's not on your end. You know what I mean? It's not on our end. So, you have if you know your title company and your escrow company, then you know that you're covering your butt basically.
Jim, did you say your office doesn't hold any escrow?
Only for property managers.
I would say most brokers today, there's only
Always goes.
two that I know of that have their own escrow accounts anymore. Because of all of the rules, and honestly, our rules are different than what the broker has to do, but it sure puts a lot of mess on their broker's desk that they don't really want.
Yeah, most,
Harbor's the only one that I know of that still does it.
The
ERA
only-
advantage.
The other time that I do take the check, when I'm working with buyers, rather than waiting to see if it gets accepted, is if I'm unsure of the buyers. If they don't hand you the check, and they say, well, just submit it, let's see how it goes, no, I want that check, because
I would say honestly, it's not a bad idea if you can get them to write the check.
it's not a valid offer, and I feel like I'm
That's
upset.
not true.
Well, okay, but it's not.
It puts them in the right
I wanna know that
mindset.
they
Yeah.
actually have the money. If
It's
they're
a
serious
mindset.
about it,
Yeah.
they're gonna write the check.
Yeah, and it
You know,
gives
and
you an
I
opportunity to make
don't
sure they're
mind,
serious
as long
and
as I see them write
close.
it, if they wanna hold on to it for the 3 days, but if they're not willing to sit down and write it while I'm there, now I've got bad feelings.
The other point too is to educate them and let them know it's getting deposited.
Yeah.
There is
and it
a
will be-
huge
it will be-
misconception
yeah.
among buyers that you are just holding that, and
Yeah,
if the deal falls apart, you can just mail it back to them.
yeah.
I'm brand new, licensed, and, as of yesterday, as a matter of fact. But I've sold millions of dollars worth of real estate over my life, but I usually bought it and I'd sell it.
Right.
I never took a deposit. People try to write me a deposit, I never take it. I say, I just gotta give it back to you, if it falls through, forget about it. And I never had a problem. So
Well-
this is all new to me, when I
Well,
mean, I understand. Yeah, I know, that's what I'm thinking, but I'm not, but I am the broker, I'm the owner, I'm everything.
Yeah.
Where now we're dealing with all these different. people.
Occasionally you have people that want to fight over it, the buyer or the seller, even if they're out of line, they want to fight over it.
I guess my question is, do you guys ever take a offer without
No,
earnest money?
no, because once you get to the point of a bound contract, you have to have
That's
an
what
exchange
you
of
gotta
money.
have, oh, gotcha.
The only time you're not
Consideration.
is with a VA loan that's 100%.
You
Right.
still would take a deposit, wouldn't you?
Yeah, the
Sometimes they're written without it though, because it's 100% financing.
With no escrow deposit?
I would still.
Would you have a valid contract if you had no escrow deposit?
I don't know, consideration, something's gotta be in there for consideration.
It'd be a dollar.
Like he just said, consideration, have a valid contract, you have to have consideration. So even if it's a minimal deposit, you gotta have a deposit.
I don't think so.
Yeah, 'cause I
The
think
way I've been
it's
seeing
the
them-
consideration is a promise for a promise, right?
Would that be it?
Yeah, and under Florida law, they consider that, so we heard in our schooling. Right?
Promise for a
A
promise.
promise for a promise is considered valuable consideration.
So the financing agency kind of covers that, they're gonna get the financing.
That's the one situation where you may not see an escrow deposit because it's 100% financed anyway.
I'll know, yeah, because that's an interesting point.
We had one come close to being litigation because there's the deposit, there's the deposit, and one night I called him up and I was like, where is the deposit? He started doing this. You know, we were thinking about this, I don't think that property is advertised really fairly. I'm like, you're back at it.
And that's why nobody wants it.
I'm like, I was just about to jump back his throat. And I realized, he's still going to go there. That's not the relationship with your customers. So, it's all about setting expectations.
Well, I've seen it where they're like, said they're going, oh, well, we don't really want to give our deposit because we're still in our inspection period, and, well, that's not the way this works, right? Unless you line up your dates.
That's like a seller that doesn't want to move out until it closes so they know the buyer's going to buy it. That's been coming up a lot lately.
I heard that one too.
Yeah, it's been coming up a lot lately. I'm not moving out of here until I know that they bought it. Well, then they own it, so when you get a default.
Yeah, all right, so it's, for some of the folks that are kind of newer, just to reiterate a few things on the contract that we haven't covered. Item number 1, on personal property, and item D and E. You should really read through the stuff that's generally included. On D, 2 things that stand out all the time, wash your yard, and not just the
was making sure that it's gonna be there, make sure you write it in there. I want to back up just to the buyer line really quick, guys. When you fill that out, obviously you're selling, you're pulling off of the tax record. Your buyer, get their ID, snap a picture of it or something, so that you know what their legal name is. Because when you're buying this thing, when you're representing the buyer, I have so many cases that come in. I had a husband insist that he knew his wife's name, and it wasn't. It was not her name. Because he always called her Cece. I don't know, that kind of
She was wifey.
But please check on it, make sure you have a legal given name, because again, it's the validity of the contract. If you don't have the right buyer, if you don't have a legal buyer, you won't have a legal contract.
So the other person will tell you, make sure you put it in here, because even though it might say it in the MLS, if it's not on here, the MLS doesn't override this.
The MLS is not a contract.
No, but that's a good point, because a lot of people think that. And the MLS offering has nothing to do if it's not in the contract.
Now, if you attach the MLS, you want this as an attachment. So it's, if you attach them on, that it you know, say you're covering yourself, but just make sure that you don't make any assumptions about the stuff that's in the house, that it's all coming with the house.
That goes to what does furnished mean, what does turnkey mean, be as specific as possible as what's being included with that contract.
So the
But we had a deal just recently where it was turnkey furnished. That's what it said in the additional remarks. The house shall be turned over turnkey furnished. And the sellers moved out of the house in like January, and for January and March, they had taken some stuff out. And I furniture,
Pots and pans are
Pots and pans.
like that.
right. So they took all that stuff out, and then when the lady, they wrote it off in June, the buyer kept referring back to the pictures and everything, and saying, all that stuff was supposed to be there. Well, it wasn't there, it was going on us. It wasn't there when we were in the contract. And she started getting on my case about, we have to sell it. So, she said the agent should have done a better job of documenting what was there. And I told her, I said, yes, I think you and your agent should have done a better job. So, yeah, that's when it came up, because that's when I realized the law.
But you want to issue the church license after the walkthrough, you should be verifying when you're under contract. That's why I say be specific if you can.
But realistically too, because it happened to us, unfortunately, we still don't have it under contract. Unfortunately, it didn't happen while we were under contract or anything. But if we know we're going to take it at turnkey, we really want to have our sellers provide that inventory list, and then we attach it to the MLS, and then buyer agents can use that as the exhibit. I mean, we had a similar situation. They came back from weekend and took everything out of our listing that we had advertised as turnkey.
There was a deal where, this was a story of a contract last summer where they bought the house fully furnished, blah, 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 they know one does what they do, and just like, yeah, what happens if that little, like, statue that was on the table over there? The seller thought it wasn't a big deal, which somehow who's going to miss a little personal connect about it, but it was worth $1,500, and the buyer, they're like, the statue,
And so like that thing too, at personal property, what's also not really disclosed is one of the pieces of that contract is everything that's attached is supposed to be included, right? So we have a flat panel on the wall, is it included or not?
so mine,
It depends on if it's bolted or not. Well, is it bolted to the bracket?
it's quick release.
So my point is, if you think it's going to be included, you better list it. Because it's just something else to fight about. If it's attached, it's supposed to be there, and if it's not attached.
I actually use the phrase, and all attached appliances and fixtures, because selling a commercial piece of property, or representing the buyer buying a piece of commercial property at one time, I include that. The seller, okay, fine, no problem, and then we go to do the walkthrough and the AC unit's missing. The seller forgot that his tenant put their own AC in. Seller had to give our buyer a new AC system.
Yeah, so in this day and age of all these electronics, and like we had a deal last week where they had security cameras on the outside of the house. And the seller had to let them 730, and the buyer wants to know where the cameras are. of stuff than underdocumented.
Okay, well, that answers my question, because I get so much redundant stuff in the contract, right? Like a buyer's agent will send us an offer on a listing, and they'll say the stove or the range, the refrigerator, but all that stuff's already there.
So here's a good point that I just came up with the other day. It used to say refrigerator, right?
Refrigerator, right? Because the garage was always not conveying.
Right. That's usually the primary. Right. The other listings that offer the refrigerator garage is called
Wine fridge.
Oh, here's the other one, how about removable storm shutters? And the, like the Teflon, whatever they, panel, stuff like that. Or the remotes that go with it. Like the remotes, part of it. You know, so there's a lot of little pieces. We've actually had a lot of these fights that, of course, we're witness to, that they want us to be part of, and we're not.
So when you're buying a listing, you're walking and taking a listing, go over all that stuff with your buyer, with your seller, and make sure if there's a water treatment system sitting outside, do they own it or is it leased?
And I like things like you have saying, you know, here's the list of included items, honestly. I know I walked into an open house, and it was the best open house I've ever seen. And one of the things that I thought was so cool was like, all of these things are included with the home, and it was made right there for everybody that came up and picked it up. And they had, I mean, obviously the seller was the one that was really meticulous about it, and they'll put the agent in all this. But it was really well done. But maybe it was the agent, I shouldn't say that. But the fact that they had every piece that they were going to include with this, and a lot of it was selling features, you know, some really cool stuff that came with the house.
Very good to burglars too.
Yeah. Here's your shopping list.
Yeah, I actually lost it. It would have been my first sale. I tell the story all the time, but I lost it because of basically it said turnkey and it wasn't. But I learned from that, even with my buyers, before I put it off, if it says furnished or there needed furniture in the house, I'll ask if the buyer's interested, what comes with the house, and I want an itemized list. I don't want, most of the furniture. I'll be like, cool, what furniture? And you're not getting the offer until I see the list, because otherwise, you know, you have that dispute. I want to see it in writing. Right, exactly.
You know, when swap out the upon strip too.
Yeah.
We have these really nice appliances. I don't know when it comes to junk from the store. Yeah, so if you aren't feeling good about the way the other side's handling your side transaction, you might want to document that you need whatever, and take pictures, all kinds of stuff. Model, you know, brand, a model, something. But it is important too, like what's excluded. So, yeah, again, if you're talking to a listing, if you're going to go out on a listing, find out if the chandelier in the dining room is going to the house. And if it's not, tell them to get it the heck out of there now before you start showing the house. Yeah. If you see there's a bunch of junk in the garage, say the guy has a bunch of empty paint cans or something in the garage, or there's a broken down boat in the backyard or whatever, use that line to make sure that stuff's out of there. And I would even put a time frame. I'd say at least 5 days prior to closing. And then we'll open there 5 days prior to closing and see what's gone. And if it's not, then I would start, if the rep comes move it, find out how much it's going to cost to move it and get that money held in escrow to be able to cover the cost, your buyer to cover the cost. Okay?
Just in case they pull the car out and there's a motorcycle.
Yeah, I told you. Yeah, so if there's anything in there that makes you kind of nervous, I would document it and make sure it's removed and put a time frame on. Financing. So we talked about furniture and stuff. You have to be careful with furniture and stuff when you're financing, when you got to deal with a loan involved. Because technically the way the appraiser is supposed to do the appraisal is if there's furniture or personal property included in the sale other than the loan, that's supposed to come off the appraised value. So you might end up with an appraisal problem if you're selling a house full of furniture. So what our agents will do, they'll have to work around that. They'll do an addendum to cover the personal property. But the addendum just never seems to make its way to the lender. I don't really like that because I think that could be construed as mortgage fraud. So I would rather do something for the sale.
Yeah.
You know.
Do you guys have a standard bill of sale that
going to do it. Then it's standard in such that it's up to fill out the
Right.
stuff.
Yeah.
Yeah, but it's separate bill, say out for like a dollar, whatever you guys want to agree to. And then, for the seller and buyer want to agree to, but I think that's a much better way to handle that.
That is a much more legal way.
Yeah.
There used to be a phrase I think that used to put like, household furnishings.
No conflict.
That's what it says.
No contradictory value, how do you say that, value to your.
And then it's the buyer and the seller, but the.
But if the contract would say that.
The only appraisers, yeah, they wouldn't, a lot of times don't do that.
That's why-
Yeah, then they're the ones that usually suggest that you do it, and then you don't show it to them. Which, then they're actually participating, they're participating in the fraud.
Right.
Yeah. So, it's very interesting.
The best thing you do is just sit down and read through this. You don't necessarily need to read through it from front to end at one sitting. But when you do read through it, like if you go to item 5 on page 2, it talks about the very last statement in there says, as provided in standard G. Says, very nice. So on page 2, force control, under extension 48. So under B, the very last 2 words is statement G. You know that? So that's at the end of the contract. There's a section for standards. So to really fully comprehend that, what I would say is read that and then go to section standard G and see what it says.
Right, yeah, go back and forth.
Don't just read it from top to bottom and then do read standard G 2 hours
Yeah,
later.
really, so read a contract one day, it's actually good education for you. And try to connect all the dots, you don't write a sample, because once you start writing them, you start to learn all the pieces that you go, wait a minute, I have to ask and I have a question about.
Yeah, because we had an agent the other day that was buying a house, so like number 6 on page 2 was occupancy and possession. Well, she had a house that was about number 10 actually. So, then you're talking about item B, check the copy subject to leases. So if it is subject to leases, they should be providing with the leases. But then again, it refers to standard B in there. The question our agent had was, who's supposed to provide the estoppel letter? Estoppel letter is a letter that you give the tenants to verify the terms of the lease, to make sure what you're being told, what the lease says is actually the tenant's agreement with it, okay? So right there in standard B, it specifically stated that the seller is responsible to provide the estoppel. It's not the agent that just read the contract. People have been going back and forth. I don't mind phone calls and stuff, but it's nice when someone's actually putting over the thought and just like
Read the section first before you call them. Honestly, there's one other thing on the first page I wanted to touch on real quick. That purchase price. Number 2, letter E, line 40. So the balance to close, not including closing costs, etc., by wire transfer or other collected funds. So basically, I have a lot of people that get down to the last day, and they don't realize that they're supposed to be wiring this fund. That they're going to write us a check, or bring us a cashier's check. A lot of them think they're going to write a check. Make sure the people, they can be 3 days before closing, 4 days before closing. That means that they can understand that they're going to have to arrange for a wire. And they can't just call their bank and they're going to wire funds to me. Unless they have an online wire system that they're familiar with, it's not going to be that easy. They're going to have to go down to the bank, get the actual dollar amount, show them the wire instructions, and they haven't made that thing. Or their bank is up north. We have this a lot. Their bank is up north, and they haven't made arrangements to get the funds down here. Now, they just flew down yesterday, but they could have made the arrangements to get the funds wired to us, and they haven't. And then they're wondering why we're being so tough on them. And the reality is, my terms of my contract say I can have collected funds, and that's to protect the seller. But I have to have money in here before I can switch this out. So until that wire comes in, then I know I can't take your personal check, because that's not going to be considered collected funds for another 10
talking about wiring, having your customers wire money, do not be the intermediary between these wiring instructions and the customer.
Just received wiring instructions from a bank last week.
Yeah.
I was floored.
So yeah, you want your customer and the title company or whoever's close to the deal, anything about wiring instructions, let them talk to each other directly. No. There have been instances where money has, the wiring instructions have been intercepted somewhere between the title company, the agent, and the customer, and they've changed the routing and bank account number on the wiring instructions. They didn't go so far as to change the phone number and the contact people. So if you call to verify funds and verify that routing it, you'll reach somebody, whoever you want.
It's about like 890%.
Yeah, and it's not covered by our E&O insurance.
Okay, so here's the thing. Our wire instructions, if we send them out to the customer and they broke into our email account, I'm insured for that. If they broke into your email account, you are not. Okay? And the biggest, and I'm not trying to pick on numbers, but the biggest weak link in this whole thing is where they are basically looking for realtors' email accounts because they know that I have security on my system much more than a realtor does or a buyer or seller does. Now, the buyer and seller are hard to find because you don't necessarily know who's buying a piece of property today. But finding their realtor that has a Gmail account or a Yahoo account that I can break into, that's much easier. There was one agency around here over one weekend, they had 5 different agents that had their email accounts broken into. And the agent that we were emailing was sharp enough to catch it because they were getting emails from us, which they had changed, not from us, but they were spoofing our account. And they were saying, did you send the wire yet? Did you send the wire yet? And you do that. It doesn't sound like my title company. And that's one of the reasons I say it's nice to work with your title company because you understand how they communicate and you feel when there's something weird. And
Well, you're using encrypted links.
always, yes, we are. And the other thing that I would tell you is that when we put this on the wire instructions, don't just accept these wire instructions, call us and verify them. So, like if somebody sends us a wire instruction, we call that person and we ask them to verify the information. In other words, if your seller says here's wire information, wire to my account, we have to get on the phone with them as a policy in our office to say, please make sure, please verify your wire instructions. And we use not a phone number on an email that they just sent us. We use a phone number from our system that you've been talking to your sellers all along. Because, as Brett mentioned, they will change your phone number, they will change all kinds of things. They will even have the gall nowadays, the fish reports, where they will call you and say, hey, I just sent you wire instructions, I want to verify them with you. And boom, the money's in Nigeria or something like that. It's gone.
Yeah, so just be really careful about that. Put yourself in that position. On item number 7, that assignability, I almost to see that when people don't check it off. I don't sure why. But I recommend using the second option, may assign the not be released for liability under this contract. Because a lot of people who are buying properties down here might decide to put them in an LLC or put them in a trust or put them in something. So just to give them that option, maybe just do a financing section. You should be talking to the lender. To find out, okay, what type of loan are we going to do? And if you're not going to finance on page 1, you should be finding out from the lender how much they're planning on financing. Is it 95%? Is it 80%?
Well, we should get the contract without knowing that from the qualification to break all the letter anyway, right?
With the number on or percentage or whatever on that line on the first page. I don't know how many times you see on the top maturity, you see a deposit and a balance to close number. Yeah. And that looks like a cash deal, and then you get a page fill, you know. Yeah. Like it's not too long ago. Yeah, so,
And then you want to make sure that you check if it's going to be VA or if it's going to be FHA, because that's protecting your buyer, locking them in,
should be talking to the lender, and if the lender's somebody like the bank from up north that they've been working with for 35 years, encourage them to talk to a local lender. And now, with Calabrese mortgage, I mean, we're almost obligated to we are obligated to offer that as an option because it's kind of like a no cost loan. So if your buyer finds out that they've got the no cost loan, and they didn't get it because you didn't notify them about it, it's a liability. It's such a liability. So here's what we're working on right now. Not only your buyer, but it's a way to get listings too, because even if somebody with Coldwell Banker brings a buyer of a television listing, they can use telephone. Yeah. Did you guys get that? It's the television mortgage is built with anybody in a transaction and deposit television agent. And they really are saving, they're giving them $1,000 of closing costs and saving them, I think, on average, what, $3,000 or $4,000 a deal. If it's 150 over, it's about 5,000. Okay, so it's got no origination fee. Right. The reason why they can do that is because it's not a profit center. They're not making any money on it. They're not advertising on, the NFL games like some of the companies. We'll hop with money from our end, we just got some life savings on their customers still. Really, we should probably offer that to our customers. But yeah, fill in these blanks, but you can't really fill them in unless you talk to the lender. And if the lender is somebody from out of the area, or one of these online services that I would venture to say is one of the giant banks like Bank of America, your chances of something going askew during that process are much higher than if you're using somebody that you know, trust locally, or somebody like California. That would definitely, even if you got a pre-approval letter from the bank.com, I would try to encourage them to talk to somebody local. We've personally run into it where geographically they don't understand that when an Orlando appraiser comes to Port Charlotte, they don't understand how far that separation is. They may have real estate specific things, like we were talking about Title V in Massachusetts with septic is crazy there, so they might get really particular about a septic issue here that's not the same kind of situation. Yeah, so if you're working with a lender from out of the area, chances are the appraiser they're going to send is going to be whoever is willing to do it at cheapest and jump on the lead the fastest online. So you might get somebody from Tampa or
Honestly, I see that. What I've heard from my realtors is they see it from coming from Tampa or Orlando, and they'll challenge local knowledge straight up before they even get that appraisal. They'll say, I want a different appraiser. I would, with local knowledge, you can do that and validate the appraiser for that area.
So using California is another advantage of Keller Mortgage. And the thing with Keller Mortgage is they order the appraisal almost immediately. Right? And we found out that, and this wasn't really typical, but I think because the closest to Southwest Florida is Tampa, it was a Tampa appraiser coming, and we said, no, that's too far away, and they got some good luck. Not very well.
Keller Mortgage is only available to buyers and sellers. They're exactly available to everybody, but they're only available at no closing costs.
The discounts were only
It could be a buyer from another agent that's one of the listings. You can still share that information with the other agent and encourage them to get it. Or if you see a pre-approval letter, you can make it an offer contingent upon getting pre-qualified with a mortgage with them and meetings or whatever you want. You can negotiate whatever you want in the contract.
Yeah, that's good.
Wow.
That's interesting.
I'd be nervous. I might be nervous about requiring them to documents that they're lender. No, just getting it through. I think I'm sure they're not re-approved. No,
We hashed that out this morning.
Okay, so
Everyone is the best.
I actually worked with an auction company, and one of the big deals that they had is if you were going to finance it, you had to go sit with their approved lender and get pre-qualified. Not pre-approved, but pre-qualified. So, you know, in other words, you were the winning, you were the little bidder, you went to
you know it. But the reason why that's important is because if we do have a claim, the deductible is $2,500 if we have all the four things that we're supposed to have, which is evidence that we offer the warranty, evidence that we recommend an inspection, that we're using the standard forms, and this warranty, inspection, resellers, it's not standard. Yeah, we have to have evidence that we should have a seller's disclosure. It's not required in the state of Florida. That's not what we do. So seller's disclosure. So
That's a total state law.
so even if, say you get a house, you get a listing on a house that's in the States, the people that are owning it now have never lived in it, they can always just write no knowledge on the seller's disclosure, and that's your seller's disclosure, right? So just try to make a good faith effort to get the seller's disclosure on every listing, and even on your buyer deals, ask for one if it's not being provided. You know?
If you want to get paid, that's the way it is anyway. We've made it a required document for the broker.
And the whole warranty can make sense, because if you didn't offer the whole warranty, and let's say your $5,000 air conditioner going out, and somebody said, well, didn't the realtor offer you a whole warranty? Guess who they're going after? Let's say they're looking for $5,000 somewhere, they're coming after me, they're going to come to Jim and say, why did you even tell me that conversation last week with the guy that's got interest? The buyer's in.
Well, if you have the buyer, and the seller's refusing to provide you with the seller's disclosure, you're really not holding.
No, you're right, but from the listing side, though, we made it required that you have an executed seller's disclosure, because then we do have control of that.
Yeah,
Right, from the buyer side, we don't.
but again, if they don't acknowledge, they can just say no knowledge and then just.
There's a bunch of any and do not know boxes all about it.
You find them trying to hide something.
Very rarely. No, normally you're going to see a red flag from the shady part of the way before that you even read that.
But yeah, you should at least have evidence that you requested the seller's disclosure if you're on the buyer's side, so that we can at least provide that to the company if we need to go there. Okay.
Also, the offering the home warranty is really an item of value, showing that you're trying to protect and have your buyer's best interest in mind. I mean, it's even if you have them purchase it, it's like $500 and everything in the house is covered. I mean, I've been in my house since 2012, and Joey was like, "Why don't you have one?" And I was like, "I don't know." But so we're gonna do that because it just doesn't make sense not to have all of your systems covered.
Especially if the house has been sitting vacant for a while.
Right.
Which chances are when they start using everything again, you're going to have a hot water meter.
For a rental property.
Yeah, you have hot water meters and toilets going out of business foreclosure. Toilets, toilets start leaking. AC.
I've had about 3 houses over the last 5 or 6 years that had a home warranty, and right after they closed, within a month, that AC went out.
We have
5 different visits.
We have an FHA, one that was bought with an FHA loan, so they had the FHA appraisal, everything worked. I just saw her Saturday, and she was like, the electricity on one whole wall isn't working. And I was like, that's insane. But I was like, we got you the home warranty, right? And she was like, yeah. I was like, call them, because I bet you it's covered. And sure enough, they're having the whole thing redone.
Yeah.
You know?
But it won't cover the ice maker and the fridge, that's an additional cost.
It's $50,000.
Yeah, it's a year.
We're short, we throw it, we have a couple different companies. There's little nuances in each of them that might be a little bit different. So you might prefer one over the other, but generally speaking, they're pretty similar. Property inspections, if you're going to do less than 15 days on property inspections, I would make sure you got an inspector lined up to be available to do it.
Especially as we roll into months.
More than one, yeah, because they call you to change.
And then that's kind of like your title company. Make sure you have somebody that you're used to, that you understand how they're going to work, what's their turnaround time, those kind of things.
Do you know what company was that?
As far as title companies, I do.
By the way, we don't have any direction that you're spending.
You'd be surprised if the
I have a lot of people that think that. A lot of people think that Keller Williams, Peace River owns part of Suncoast One, and they do not. We just work together.
Build a relationship.
It's like, it's
It's put us on a lot of our efforts that we our FES classes with just about everything.
Field trip Friday, awesome lunches.
I'll give you one.
We never came to our office.
Do not.
He's expanded everywhere but there yet.
Yeah. One of the things I think you ought to make sure you read is the inspection clause in the as is versus the inspection features of the general repairs and maintenance contract. And understand the items in that contract, the other contract, that will be, the seller would be required to repair if they show up as a defect in the inspection. Right? So,
Like the percentage thing right up to, like
the standards one, yeah, the standards one.
So if they're going to go to the dollar amount too.
Yeah. Please get so we have to make sure that we talk about.
On page 4, line 183 and 185. This is about assessments.
Oh, yeah.
And I will tell you that if you don't pay attention to this and your seller's agent checks off a box that hurts your buyer, it's going to hurt you. Okay? This talks about who pays the time payments on assessments after the closing. So the best scenario, the best example is like over where Brad and I both own property is over in the Spring Lake area where they've done the sewer, and the sewer assessment is $14,000, $15,000.
Yeah, $550 a year for all 20 years.
Paid over 20 years. Now, the question is that this is answering is whether your buyer is paying all of it before closing, or is the seller taking over payments, which is a tax bill? I don't know.
Oh, yeah.
So I'm sorry, seller paying all before closing, I'm sorry. The seller's paying all before closing or at closing, or is the buyer taking over those tax payments after closing? And I've actually had contracts that have come to me that I'm going, for a property I'm selling, I'm going, oh, no, I'm not doing that. Because they're trying to slide it by and say, well, you're going to pay all that off at closing. Well, there's a $20,000 bill or $15,000 bill that your seller is not expecting to pay at closing.
So is your TV guys with the new first action cut too?
Oh, that's right. First,
Well, and make sure you realize this is just for public bodies. So this doesn't cover condominium associations or homeowner association assessments.
So that's the biggest part. We've run into that. We've run into four times over the last couple of months. We've run into that, and I've had to argue with that agent who typically is an uneducated type of situation where they haven't been trained on it. And well, what about the HOA? There's an addendum that covers that. This is only municipality stuff.
Right. Right, but with the HOA and the condo disclosure, you're supposed to get all the documentation that goes along with it, the financial statements, the budget, minutes of meetings, which if it's going to be assessed, then there should probably be some discussion about that in the minutes of the meetings. And that is the rules and regs and all that other good stuff too. But I think a lot of agents don't really pay attention to what that calls for, and they let things slip by, so you can easily miss an assessment if you're not getting all that documentation.
I was going to say, if you're new, or even if you're not new, have somebody else look over the contract after you're done looking over it.
Yeah, I'll tell you right now, I have nothing to do with your tax business.
It's easy and it's simple, so always have a second party to through it, somebody who trusts it, that's meticulous and will do these things. It can cost you a lot of money, but it can cost you your license.
And one of the frustrating parts about that is the listing agent typically hasn't gotten all that information from the seller, and you're hounding them to get it.
Right, so when you're taking a listing on a condo or something, get all the documentation up front. Because I see time and time again, my daughter just did it, by the way. She had a buyer for a condo in St. Pete. She ended up spending $45 to buy the documents that the other agent should have provided for her.
And that's cheap, because around here it's $250. Whereas
decided we're gonna go through with the deal.
And if you attach all those things in Matrix when you put the listing in, it also lets the other agents know that you know what you're doing, and it's going to make your negotiation point stronger.
That's a good point. I would even say you should take the condo disclosure or the homeowner's disclosure and attach a complete copy of that, attach that to the listing. You know, so they have to go with the offer.
Because Jim, if you don't, what typically happens is if the condo association disclosure has not been provided to us or HOA disclosure, whatever, I'll send it to them as part of the contract, but blank. And they're like, you sent me a blank HOA addendum. Yeah, because it's your job to make sure it gets filled out. I'm not going to have my buyer sign a blank addendum.
Well, the problem is every time, like, you can go on the MLS, and if you just take the information from the MLS and put it into those addendums, chances are you're an agent either look at somebody else's listing and or they got an old set of condo documents or the information in the MLS you can't rely on. Just I just want to point out that item F, standard F on page 8, time is of the essence. Keep in mind that the contracts, it's calendar days, so if you say 7 days, it's 7 days, it's not 7 business days. And then if a period in the contract, like an inspection period, a financing contingency, any of those periods that you're dealing with in the contract, and on a Saturday, Sunday, or national holiday, then it rolls over to 5 o'clock on the next business day.
Mine's 420. Big time.
So just be aware of that. And it says there it shall extend to 5 p.m. of the next business day. That's the only time that's stated in this contract. So everything else goes to midnight.
Well, 11:59, right? Yeah, 11:59, 59.
So just so you're aware of that. And a lot of mistakes that people, what's that?
That second,
You have to assume because 12 is the next day. So you want to check the calendar because I set dates on contract.
I said it for me.
Yeah. You don't want to come in on Sunday.
I'm not coming in on Sunday to do it, and you don't want to do it in them after you've done that work. So.
No, and that's a good point though, because even me with all of my experience, as I said, it doesn't matter how long you've been in this business. 4th of July, Christmas, those are the kind of dates that make sense. Yeah, but I don't know when Labor Day, Memorial Day, and all that stuff. So look at the calendar.
On this day, the bank's closed. Guess what? We can't close for the next
So that's a good point. Even if the title company might be open, if the bank's closed, the title company can't close it anyway.
Right.
Yeah.
Yeah, just get a wire. We can't wire funds out.
Right, so you also don't want to do it the day after the bank is open and so for 9 a.m. There's no everyone on that.
Well, I try to avoid too is I try to avoid Mondays and Fridays and Mondays. And I try to avoid that. I try to avoid the very end of the month too.
Yes.
So
I would say just Tuesday, Wednesday, or Thursday, first or third week of the month, that's when you get the best closings. Because you're not up against 9 other people at the same time.
Can I ask a question, Roger? I can't be out of this contract. Why would somebody use this other contract with that 1.5% or whatever the negotiation is? Because if they do that, don't they lose all their contingencies? Right. Hey, there's a problem. Okay, great. I'll fix the problem. Right. As long as I fix the problem, you're still required to buy the house.
yeah. So that's the biggest difference is as is, it gives the buyer the easiest way to get out of the deal.
Yeah.
You don't have to have it. You can just wake up one day and say, I changed my mind. And as long as you're within the inspection period. Some buyers, or some agents, like giving the buyers that freedom. Like if I was on the listing side, I would rather use the general person agents because they know I got a more serious buyer. But,
The thing that I decided that it basically says your seller's going to pay after this. And I don't have regard
So I look at it 2 ways, and how I normally explain it, like during filter fire or whatever, is if your buyer's really in love with that house, like really in love with that house, they have no intention of walking away, then a lot of times they'll want to use that as opposed to sell it
seller put in there, I'll only accept as this contract. Everybody's like antenna went up, like, oh, that was wrong with that house, or they,
Right, it was scary.
when Charlie came around, and then everything was damaged, so this was really pretty much the only thing everybody was using. And then the foreclosure usually bills started, so then you can, we only let you use these. So everybody got used to using these. Others, there's tons and tons of agents out there that have never done a general appraisal.
There's agents that don't know it exists. I think, yeah, it is the only for a contract.
Yeah. And the other thing is like, there for a while there were so many cash deals being done, there are agents, not only did they never use that contract, they never did a financing deal. They might have been in business 2 years and never did a finance contract. So they have no idea.
So 90% of their deals were cash.
Yeah. So anyway, I don't want to keep getting longer, but just try to read through this. And usually what we try to do is ask if anybody has any specific questions or put in the beginning and class. There's no contract that's really, ask if there's anything specific that you wanted to cover.
I want to say one thing, this section 19 on page 12, I think is the right section. All the addendums that are there, before you go and write your own verbiage in additional terms, if there is an addendum that exists, use it. Because a lot of them are fill in the blank and it will keep you out of trouble. The minute you start writing your own terms is the minute you open yourself up to a mistake.
So the reason why we recommend the contract, the bar contract, is because it was approved by the Bar Association of Realtors in conjunction with the Florida Bar Association. So if I'm a lawyer and I get involved in a situation, the first question, and they didn't need the bar, the first question I'm going to ask is, why did you use the bar? Why are you using this? And then you're going to try to make it look stupid for not using that. And then the other thing is, like Kevin said, if there's an addendum, before you start writing your own addendums, check and see if there's an addendum in this list. Okay? And if there is, we should be using that, and we shouldn't be just drawing off their language.
It doesn't have to just be in this way. There's plenty of other here that may cover what you need to. That's why we're going on.
The minute you write in additional terms, you're starting to create other language for the contract, which does that make you an attorney? It opens you up to litigation.
You start writing like Shakespeare, it could be construed.
Yeah, so if you don't have to draw out, thou shalt leave the refrigerator. If you don't have to draw up an addendum of some sort or additional terms, just be clear and concise. You don't have to be all flowery.
Yeah, you just need
Have somebody else read it for you.
Can I add to that the counter offer form? That's my favorite. I love using that instead of people crossing things out and reinitialing all over an original contract, which we're also not supposed to do. There's a counter offer addendum, and you just click the little box that says seller counter buyer's offer, and then you just get that addendum and fill that out. Super easy. And that's what we're supposed to do, and a lot of agents will argue with you, but it's much nicer.
They go back and rewrite it.
And you're not supposed to, you're editing a contract.
It's a little bit of an education moment for your seller, because the seller's like, what do you mean I have to sign this form?
Yeah.
Okay, because when you use a counteroffer form, it does counteroffer this, but they still have to sign the original form that you're counteroffer.
So you see that box on page 11, at the very bottom. Here's the option of either counteroffer or rejecting. That's what John is referring to. And there's a counteroffer form.
And all you do is select, you're changing the contract, the closing date on it, super. Then you fill in the dates that are changing. If you're changing the price, you put in the price. What comes to the house, you just click the line and you write what changes, and that's it. And then if they don't like that, then you do another counteroffer form instead of crossing things out 100 times over a contract and not being able to read it. And you're not supposed to do that. You can't see sometimes who signed what. You're opening yourself up for litigation.
Well, obviously there's you send it to us and you email it back and forth 3 times. And somebody scanned it and faxed it, and then they send it to us and 4 people crossed it out. Guess what? It's really hard for us to figure out what the heck you guys are playing.
Yeah, there were instances after the whole boom and bust thing was the contracts were written and all that. negotiation and the buyer, and the seller, and they won't budge, and the agents start agreeing that they raise the commission money at the gap. I mean, technically, you're not supposed to use it as a bargaining tool. You're not supposed to use the compensation offer as a bargaining tool to try to get the deal done. But it happens, and but whatever you write on this contract, this is a contract between the buyer and the seller. It's not a contract between the agents and the seller or the buyer. So really, I don't think that has any legal standing. It doesn't. Yeah. So a lot of times you'll see agents keep trying to make it party to that contract, don't they? Yeah. They keep, sometimes you'll see agents put like 3% or something, whatever the commission offering is on it, but it means nothing. I mean, so if you're only going to deal with the commission, that's how it needs to be.
So we're going to deal with the commission, that's kind of between you and the other agent, but the seller's agent has the commission agreement, right? It's a separate agreement, and that's what they're trying to point out. And basically, there have been cases in front of FRAC that have said, well, we agreed on changing our commission, it's right here in contract. But that contract doesn't involve you. You're not signing as a party to the contract. You're listed on there. But are you the party? You're not the buyer or the seller.
Now, in our office, everybody's authorized to run their business the way they want to run it. So if you want to make a contribution to take care of the open air commissioner, or you just want to file a legal online to you or whatever, you have every right to do that. I just would be cautioned that I'm not just blindly across the board doing that willy-nilly, because you end up giving all the money away. I mean, I had a conversation with one of our agents the other day. She was selling a $65,000 condo. And she was getting out of referral. She was going to have 25% referral. And she was buying a whole lot of time for $400. By the time you're done, you're getting like a 50% of this deal fell to tax. So just be careful. I mean, you work hard for your money, so forget it. That's it.
I thank you guys for listening to me. I can answer anything. Anytime you have a question, feel free to call. If I'm not there, somebody in my office will answer. Yeah.
Vince, welcome aboard, I think.
Tomorrow we have a really good panel. We advertise again. We have a really great panel with Sarah DeRogers tomorrow.
Sarah
4
DeRogers.
o'clock. She's going to be talking about how to give the ultimate customer experience. So for new